Hello.
An excellent break this. My Lord, with your Lordship's permission, my Lord. Pursuant to one of your Lordship's orders, your Lordship was to decide the order in which we were to address your Lordships. Unfortunately, we are not able to come to any kind of consensus. This is not a review petition. It is, in fact, a reference, my Lord. Now, my Lord, in the old days, we started by seniority or we started with government council. And we are unable, because if, my Lord, your Lordship's guillotine of 4 o'clock tomorrow is there, some of us may as well go home. And all the work that we have put in the last 6
I don't
weeks.
think your Lordship
let
would
me
stop.
Stop, please. You have a habit of interrupting. Kindly stop. I'm addressing
Dignified silence is my response.
the court on a genuine problem.
Dignified silence is again my response.
All right, keep quiet then. My Lord,
Again, my response.
I don't like this bickering, my Lord. I have been in this court and another court.
Entire bar has this.
My Lord, our
Nobody
problem,
likes
our problem.
this bickering.
Please keep quiet.
No, please, I think at least address.
My Lord, I resent this intervention by the solicitor.
Please,
I know he's a man of great eminence. Our problem is this, my Lord. It is singularly impossible for us to be accommodated. Singularly impossible. Now, your Lordship says we'll read your written submissions. Your Lordship won't. Your Lordship is you are the most overworked judges in the world. There is no way in which you can read the written submissions in the way in which we might want your Lordships to do. Because we write written submissions to assist our oral submissions, not the other way around. Those come right at the end, my Lord, when the whole case is over and your Lordship says any more. And of course, the learned amicus is here, and he will certainly guide your Lordships on all our presentations. No problem. But this is a very serious problem, my Lord. I have great reservations on what the solicitor argued yesterday. And he very honestly and very candidly said that other people on this side disagree with many of the propositions.
Not all.
And will you keep quiet? I have
Again, my Lord,
My Lord,
dignified silence.
my Lord, this is not a dignified silence. It's an undignified, uncivilized interruption at which he's a past master.
If we have been able to understand the problem, the
My Lord,
solution.
either your Lordship fixes the order,
Exactly. We will fix it. That's why we are telling.
and then, my Lord, comes the second problem.
Now, please.
I'm very sorry. I'm very sorry, my Lord. I'm obliged.
The first problem, the solution is, now that Solicitor General has started,
Yes.
we will allow him to complete. We
Yes.
will allow him to complete at the earliest. And thereafter, we will simply follow the order of seniority among the senior counsels.
Very well.
Probably it seems that between you and Mr. Vaidyanathan, I'm not sure, you must be senior most one.
We have a service.
I am appearing for a review petitioner. I am appearing for a review petitioner.
I am appearing for a
Mr.
review-
Giri is appearing
I'm
for a
appearing
review
for the first.
petitioner.
My Lord,
Review petitioner should be heard.
Direction, my Lord.
My Lord, may I answer that, my Lord, for a moment?
Review
my Lord?
petitioner should
My
be
Lord,
heard.
my Lord,
No, no,
your
no.
Lordship is not deciding the review petition.
That's a
yet.
different matter. But the review-
Therefore, whether they appear for the review petitioner or not
My Lord, that may
is
not-
irrelevant.
That may not be
At
fair.
present, your Lordship,
fair.
at present, your Lordship is
It
concerned.
doesn't mean that I can't also make a submission.
Please.
But you have been doing it.
try to
for the last 10
accommodate.
minutes.
Let me finish.
One person is addressing.
Let me finish. My Lord, the other problem.
May I suggest, my Lord, if your Lordship permits, and I'm seeking your Lordship's permission. My Lord, so far as I have read submissions of all on supposedly this side, Lord, Mr. Dhawan's submissions are more contradicting the remaining submissions. I will have to perhaps, my Lord, give a rejoinder to his submissions more than, my Lord, the other sides. Lord, my learned seniors, my Lord, who are on the other side, Lord, they have other nuances substantially on the same line. So I was, my Lord, therefore, my Lord, of the view, subject to what your Lordship decides, that after my submissions, which I'll complete without repeating anything, the other nuances on the same line can also be placed before your Lordships, and thereafter,
Lord,
Mr.
my Lord,
Dhawan can submit
My Lord, my
completely
suggestion.
different idea.
I'm sorry.
Solicitor General,
My Lord,
that will create complications for us also, because if we start hearing three lawyers on a particular point, then another two countering them, then another countering, this will be an endless process. whatever Mr. Dhawan want to say, let him say, wind up, then no question of Mr. Dhawan, then we will request you that please don't again ask for time that for rejoinder
My
or.
lord, there is no question of any rejoining on this side.
0.25.
We place our observations. It is in your lordship's hands. Your lordship will decide. Simple.
Only request.
Now, if your lordship is with me, well and good. If your lordship is with him,
Mr.
well and good, my lord.
Mr.
The
Dhawan.
question of us rejoining, my lord, inter
second
se
apprehension.
does not arise.
Now apprehending the second apprehension. We understand that because of the overburdening of the court, the lawyers sometimes have this apprehension that we will not read the written submissions. But the idea of listing this matter in April was only this one, that we can utilize our summer break.
My lord, I fully appreciate that.
That is this
I
kind
fully
of matters can't be heard in continuous working days. The idea is only this one. So therefore, we request both sides that please try to save and use the minimum oral arguments. Rest you can point out that this is the argument raised in para so and so, page so and so of your written submission. We will note down, we will take it from there also.
My lord,
But
Very well.
Lord, there is one more suggestion, my
my
lord.
lord,
that
may I,
has to
may
be-
I, may I?
it does not mean that we are gagging the oral arguments. We will hear the oral arguments.
My lord, what I intend to do is, I will make the oral argument and refer to my written submission, which I'll hand over to your lordship.
Let me,
No, my
I
lord,
don't want to read the judgment.
let me make
no,
one.
my lord, the one issue is
Not
the
beyond-
the non-designated lawyers, my lord. We have to be ignored.
Now,
That we are appealing for the review petitioner, but
Mr.
then
Vaidyanathan,
questions
Mr.
of.
Vaidyanathan, Mr. Giri, you will have the advantage of hearing Mr. Dhawan. If you feel that your arguments require revised, you can,
May only say.
now let us resolve it. Now,
My lord, they non-designated seniors.
so,
They are all juniors to us, except the one, sir.
That may only respect.
Well, we get 10 minutes of.
That Dr. Dhawan will come immediately
That's what
after
he
both
told
of
us.
us.
He told me also
Yeah,
the same thing.
I am not privy to this agreement.
I think Dr.
But that's
Dhawan had told me this.
I will,
I will be limiting myself.
we can do, you see, this much we can leave to the, after all, you are very respectable senior members of the bar.
Yes.
If Mr. Dhawan agrees that after Mr. Solicitor General, Mr. Vaidyanathan and Mr. Giri can also sum up and thereafter he will argue.
Yes.
We have no difficulty.
my lord, may I indicate, that I want to follow the solicitor, if I may, my lord.
Lord,
Lord,
I would
I
I'm
request,
very grateful for your
That
lordship.
we have been in the matter for, from the,
Mr. Dhawan, immediate after,
Yes.
the Solicitor General and the.
and Mr. Nataraj. Mr. Nataraj is coming next to.
We will immediately.
Let Mr. Natarajan supplement the Union of India's.
Yes, my lord.
He'll take a few minutes.
Lord, and there is,
Then I will start after that.
the few minutes, my lord, nobody can accept what, nobody can.
This is the,
Lord, only one request, Mr. Dhawan's apprehension can again, my lord, taken care of, subject to your lordship's agreeing, that this 3 day can be extended for a half a day or something. So, my lord, everyone would,
Extension we will see later on, because you see, our past experience show there is a lot of replication. There are lawyers, I'm sorry to say, they only appear because the cameras are there, the live streaming is there. These are not acceptable to us. Yes, I must be very clear about it.
so, my lord,
Because when-
after
if
3
you
or
don't-
4, my lord,
anybody wants to
seniors
settle, then
argue.
Please bear with us also. We will hear all prominent lawyers, those who really want to, and if
Contribute.
anyone says, yes, I have a new point, when you ultimately hear the same point, they try to repeat it. That is not acceptable to us.
bear it in.
No, my lord, I will be addressing the court.
Bear it in mind and we'll curtail the time, my lord, bearing it in mind.
Or,
We
my
don't want
lord,
to disturb your
I'll be addressing the
We don't
court
want
on
to-
issues which nobody would be addressing.
It's all right. We will
But
hear.
will your lordship give me 10 minutes me or not?
A few words, my lord.
Lordship is not answering me. I'm requesting, there's no answer.
Mr. Mehta already more than half an hour goes. 10 minutes we have taken and rest.
Yeah, Lordships can answer in one word.
I can't do anything.
I'm only suggesting that review petitioners who are proximate to the cause who have participated in truth.
No, we will, now this is the order.
We're only saying that.
See the order of preference after Mr. Mehta, Mr. Vaidyanathan and Mr. Giri or Mr. Nataraj.
Lord, I want to follow Mr.
Lord, he may want to follow your lordship is the final one. Lord, it's too bad to be too good for them.
My Lord, with Sabrimala review.
I'm on the
concerned with
questions of law. We are on the question.
That's not there is. Dr. Dhawan yesterday said so.
Petitioners or not. My Lord, I have no difficulty in packing up and going home.
No. These kinds of threats do not work.
No,
Sorry, I've got a threat.
No, but that's a threat, sir.
no,
We have been in the matter for.
my lord, yes.
If I fight this court.
So all this is.
And you have indicated that, how much
I want to follow after the
How
Union
much
of
time you
India.
require, Mr. Dhawan? Please tell us.
After the Union of India.
Please tell us how
I'm
much
very-
time, how much time do you require? We are.
Very, very. I'm very.
How much
No,
time?
please tell us how much time do you require?
approximate how much?
Approximately.
About 2 to 2.5 hours with the use of my submission.
That's it.
Lord, I
Which I
will
will
take
hand
90
over to-
minutes, Lord.
Lord, I'll
Your
also.
Lordship, I will take 90 minutes.
It's all right, you can take up after that also. It's not that we are not granting time, that we are granting time.
Too bad to be too
My
good.
lord,
Right now, let us start, please.
my lord, my lord, your lordships have, your lordships,
Order that.
Yesterday we were told.
In this case.
Yesterday I was told by Dr. Dava
No.
that he, no, you sir, please don't say that.
I am sorry.
Yesterday he told us that he will follow us.
my lord,
Lord, your lordships may,
Right, Mr. Mehta, you please start now.
Lord,
my lord,
The Jain religion want to know if your lordships will be giving time to other religions such as Jainism to address your lordships on the question.
Mr. Venugopal, we have fixed, we have got the time schedule for everyone.
Already.
I know that the request received from different council, we are not going to grant the time as requested by everyone. I wish to be very clear about it.
my lord,
Once the arguments, one side, from the, Mr. Mehta's arguments are over and some 2, 3 more elaborately arguments take place, we will let you know that how much time you require to,
my request, my humble request, your lordship is I need 10 minutes time. I have the first review petition.
10 minutes only when you will spare the others.
All right.
Lord,
May I be permitted
we
to
were-
say something, my lord? My lord, I must say I'm in complete disagreement with the submissions made by the learned Solicitor General. And I wish to say that on my side, I am the senior most. So I would like to know whether I will be addressing you first. I assure you that I will not take more than an hour, maybe a little more than an hour, maybe an hour and a half.
Grant you 1
But
hour.
I assure, and my lord, like I did in the previous bench, after listening to all of them, I will give you a brief 5-6 page submission and I will stick to that. But I want to hear all of them out before I put pen to paper.
That's why last time we said that we really commend you, because within the time limit you were able to.
I will do it this time also, but I will have to go first because I am the senior most.
Can be done, it can be, once you know that within.
And I will not take more than the time you allocate to me. I assure you of that.
We are not sitting like American court that will put a bell immediately on, but at the same time, we respect from the, and with this much we expectation from the bar.
Because, my lord, we are the
Okay,
ones
whatever
in
your lordship decides.
disagreement with the solicitor.
Whatever your lordships decide, we'll go by it.
Very deeply attached.
Mr. Vaidyanathan, how does it make a difference? If you can answer.
Stand on this.
See,
Let things go, Mr. Vaidyanathan. I think that's
Now
not a
let us
substantial
start.
issue now. Please wait, we are going to hear all of you. I hope, hopefully we'll hear you clean and full, no
My
problem.
lord, obliged.
No problem.
On the any live stream.
there is a beautiful statement by Einstein,
64 of your compulsion to come to.
64, but
Yes.
before that, and this has no relevance with, it is, any resemblance is purely coincidental. When Mahatma Gandhi died, Einstein said,
Human flesh and blood.
it's too bad to be too good. Lord, now please come to page 64. Lord, what I have done during yesterday, Lord, I have curtailed my submissions and I have
You can translate, retranslate it. It is too good to be very good.
no, Lord, I was referring to, anyway, Lord,
I know it applies to me, but I'm made like that, I can't change
Even
myself.
Mr. Giri also, Mr. Gopal Subramaniam, Gopal Shankar Narayan. my
What
lord.
your lordships? Very. So,
Anyway, my lord, let's not go into it. There is a chair, my lord, there is a chair.
Your Lordship was most gracious yesterday. I'm very deeply.
Lord, what I have done is, Lord, in the first section, my lord, which is judgments, my lord, the journey from Sirur Mat to this, my lord, I have in my own way curtailed which judgments I will not cite, only one line I will say this is the ratio. And in other judgments, I will only read few paragraphs. And thereafter, I'll come to my submissions, my lord, because submissions I have not started. Even in submissions, as my lord, the Honorable Chief Justice of India has said, that I'll give the proposition first and read 2 or 3 paragraphs. I'll not read, my lord, the entire thing. My lord, that's why we will have to, my lord, coordinate. My lord, we do not have, my lord, that capacity to, my lord, use our rollers, my lord. And therefore, my lord, please come to page 64. Now, my lord, 3 things. First of all, Lord, it is 1.4. Lord, your lordships,
64 of this,
my lord, 64 of volume 1.4, Roman 1,
64 of the compilation.
compilation, there is judgment compilation. Lord, only one thing I must at the outset point out, written submission, written submission.
PDF page.
PDF would be, my lord, 67. 3 pages, my lord, is the difference. Lord, one more aspect your lordships may notice, it's not on the merits. Page 67.
52 para is there, it's a 1.4 volume.
Yeah, yes, my lord.
Starts
Dargah committee,
after
Dargah committee.
era.
Yes, Dargah committee. Lord, I read 3 judgments, Sirur Mat, Ratilal Panachan Gandhi, and Devaru.
That's it.
All 3 judgments have one common factor. The person who was affected filed the petition. Right? Now, my lord, kindly see, Dargah committee takes a completely different route. My lord, what happened, my lord, here was that the government took over the administration of Khwaja Moinuddin Chishti's Dargah. And the Dargah committee itself, the affected party, approached this honorable court challenging, I'm sorry, my lord, my Justice Amanullah has, my lord, some problem.
Yes.
Your lordships get. Lord, Dargah committee challenged that order, the act of the state government, whereby they took over the management. And Article 25 and 26, my lord, came in for consideration. Now what happens for the first time, my lord, in this journey, in this judgment of Justice Gajendra Gadkar, my lord, I am mentioning the name because in subsequent judgment, the courts have said obiter of Justice Gajendra Gadkar. Therefore, my lord, I am just naming the judge. Normally, we don't. Lord, kindly see now page 66, only the highlighted bold part. Rest your lordships may read, my lord. And I have no...
I highlighted portion of paragraph 33.
Yes.
It starts from page 65.
Yes, my lord, at 66. And I do not doubt that your lordships would read it.
Only just a second, just this paragraph 33 of which judgment?
Of the judgment of Dargah committee, my lord, the judgment is 5 honorable judges.
Okay. All right.
62 1 SCR 383, where it takes a different route than the route taken, my lord, in Sirur Mat, Ratilal Panachan, and Devaru. Please have a look at, my lord, the bold part only. My lord, I have no manner of doubt that your lordships reads everything. In your lordship, we read other parts also. Whilst we are dealing with this point, it may not be out of place incidentally to strike a note of caution and observe that in order that the practices in question should be treated as a part of religion, they must be regarded by the said religion as its essential and integral part. This test is never laid down in either Sirur Mat, Ratilal Panachan, or Devaru. And Sirur Mat is 7 honorable judges. What they say, it should be essentially religious. It should be internal. It should be internally religious. That's what, my lord, the expression used. Now it becomes essential and integral part. Otherwise, even purely secular practices which are not an essential or integral part of religion are apt to be clothed with a religious form and may make a claim for being treated as a religious practice within the meaning of Article 26. Similarly, even practices, though religious, may have sprung from mere superstitious beliefs and may in that sense be extraneous and unessential assertions to religion itself. Accretions to religion itself, unless such practices are found to constitute an essential and integral part of a religion, their claim for protection under Article 26 may have to be carefully scrutinized. Now, my lord, read. In other words, the protection must be confined to such practices as are an essential and an integral part of it and no other. This test is applied, so the court would sit, the secular court would sit in judicial review over the faith and belief system and decide whether your particular belief that this is an essential part of my religion is correct or not, and for which the court will have to necessarily examine the scriptures, several other scriptures in case of internal pluralisms, and come to a religious conclusion that this is religious but not essential.
The solicitor, now,
Second,
their understanding is on the touchstone of Article 21(2)(a). You can't just see, what they say is religious practice is different and then religious belief is different. And then you 25(a), you also read it. There should be some sort of a connection. Where loose connection will not be there, and subject to 25(a) says political, economical, and other factors, and secular. What they are saying is only reiterating in 25(2)(a) in a different way. They don't say anything about belief. Now we are only on a practice.
there are two things, my lord. Subsequent judgments apply this test and say that no, this is not essentially religious, though they are religious. For example, appointment of archakas.
Probably what we want to point out is
My lord, can I?
two things. One is the expression essential, which does not find mention in 25 itself. That expression has been borrowed.
Correct.
And
I'm
it is
great.
precondition to religious practice. So religious practice has been now made essential religious practice.
Yes. My lord, second point, which is, my lord, really objectionable, is that how would, I'm posing a question to myself, this court decide what is superstitious practice? That is one. That is on judicial review, but there is more fundamental question. But suppose there is a superstitious practice. I'm sorry, my lord justice.
Yes.
But there is a superstitious practice. The answer is not for the court to decide this is superstition. It is under 25(2)(b) for the legislature to say, no, we will reform it. This is only superstition. And I have the list, my lord, I'll just produce, of statutes which are passed. Black Magic Act, Prevention of Such Practices Act, etc., Prevention of Child Marriage Act. Child marriage is a reform, not superstition, but there are several superstition specific statutes. So it would not be in the judicial review for the court to say that this is superstition, this is religion. If it is religion, it is not essential part of the religion. No, that is my submission. Now kindly come to my lord.
Mehta, you made it too simplistic. The court has the right and the jurisdiction in judicial review to hold whether it is superstitious. What will follow is for the legislature, how to deal with it. But then the court, you can't say that whatever is the last word, the legislature decides. Probably that may not be, you have to address.
I very respectfully, my lord, have a separate view.
cannot set a straight, white-
Secular court cannot decide a religious practice as a mere superstition, because your lordships do not have that, my lord, my lord, scholarly competence. Your lordships are scholars in field of law,
We have to
not in the
classify-
field of religion.
but we have to classify those things which will have the color, because once you come to the court, we cannot come sit idle and just say, no, everything is off.
There will be practices which in from north.
Lord, something may be religious for me, something may be religious for, say, Nagaland, may be completely superstitious for me. We are in a very, very pluralistic society with variety of people, variety of religions, a variety of belief systems. And it would be very hazardous for the court to say, look, the Nagaland, I'm just giving a hypothetical example, any state, Maharashtra has the Black Magic Act. They may say that in our area, this is the practice which is prevalent, which everyone who are representatives of the people agree that this is superstitious, and therefore they will prevent it under 25(2)(b), because somebody can get up and say, Lord, it is assembly or parliament is my representation. I am present through my representative. So somebody would get up and say, this is not superstition. This is the logic behind it. Then they would decide whether it's superstition or not. But my lord, for few honorable judges who are very learned.
Come back to the basic question that after the law is passed, it is justiciable. You cannot say that we are totally outside. The legislature has the last word.
Let us take a situation like witchcraft.
Which?
Witchcraft.
Craft.
Like,
Yes, my lord.
if witchcraft is considered as a part of religious practice, would you or would you not describe it as superstition?
I will. But my lord, your lordship.
Your argument from there taking off will be, it would be up to the legislature to prohibit witchcraft and regulate any practice which promotes witchcraft.
My lords are right.
Let us say the court is approached under Article 32 to 26, saying, see, there is a religious practice of witchcraft. The legislator is silent.
Yeah.
Cannot the court use the principles of unoccupied field to give directions for prohibiting such a practice, keeping in mind, and I fully understand your arguments, not going into essential religious practice or otherwise, but the beacons of prohibition like health, morality, and public order.
Lord, it would fall within public order,
Yes.
morality, and health, not because it is superstitious. Lord, there are two answers. Allow me to answer that. Lord, first of all, when your lordships are examining jurisprudential doctrine, your lordships would normally not take extreme examples and test it.
That is one of the jurisprudential tests.
No,
To
Lord,
take a proposition to an absurdium and
Lord,
see whether it holds or not.
that may perhaps, Lord, in my submission,
What my brother is saying is this, see, it is right for you to say, subject to their saying, we can adopt a hands-off approach. But to say that it should be complete embargo.
I'm not, my Lord, pitching it that high.
Yes, that is
See,
what,
as a-
we understand your submission.
As you rightly said,
That it is
it has to be
primarily
tested.
the
Yeah.
purpose of the legislature under clause B of, clause 2B of Article 25. But that does not take away the residual jurisdiction of a court in an appropriate
Lord,
case.
I never argue, my lord, because this argument always fails against the jurisdiction of the court. Court is always zealous to protect its jurisdiction, and rightly so. My lord, my submissions are twofold. A, if something is there like witchcraft or like cannibalism or something, my lord, like human sacrifice, which shocks the conscience of the court
On the face of it,
It's-
it
it's
does not
normal.
require any adjudication per se.
per se.
We
my lord,
understand
which-
for your argument. See,
Yes.
we cannot replace ourselves with respect to an expert in that field. So
And
theology, we can't go.
Ultimately,
It's only how you bring within the ambit of judicial review.
That's correct.
The moment there is this kind of practice, the court will simply say that either it violates the public order or it violates morality.
Morality or health?
Violate the health.
Yes, yes.
Once the court, because that is what the constitutional principle.
That's the limited point I'm making. I'm not saying that
Court instead of
and
violating-
touch it. Touch it.
We agree.
Your lordships can even say that we request the
When-
parliament to come out with the law on this point or whatever.
Yes.
The discretion, my lord, depending upon the facts. But superstition per se.
Solicitor, the approach of the court in such matters also must be to determine the essential religious practice from the lens of the philosophy of that particular religion. You cannot apply some other religion and say this is not an essential religious practice. The approach of the court is to apply the philosophy of that particular religion,
Lord,
subject of course to If
Public
it goes
order.
against
Public order, morality and health.
then the
Because
court can always strike down that.
certain,
So-
certain.
Court is important rather than saying whether the court has a jurisdiction or no jurisdiction. How the court must view that from the philosophy of that particular religion,
No,
the
would the
deity.
court examine and adjudicate that this is the particular philosophy of this particular religion? That's the question.
Assisted in saying what it is.
We put it in like that. See, it is like the difference between an action which is void and voidable. If it is void, then it requires a declaration, then to that extent we can. If we have a very
But-
limited role to play, if it is so apparent. So like example is given like Sati and widow remarriage, something like this, which has been there earlier. If, so let us say that it's not been occupied by any legislation, court can indicate to that extent, subject to covering it up by the legislative later point of view. I appreciate your argument, we can't go beyond and take a different role and which is not been supposed to be assigned to us.
Like examining
that's
scriptures
correct,
and
that's
deciding what is the core idea behind this religion. That is something which your lordships would not do.
Because if
No, my lord.
the concept of logic you can't apply to religion per se.
Cannot.
That we can't
That
apply them
cannot
only
be, my
with
lord.
very dangerous
Logic,
consequences.
rationality to
That's correct.
faith and belief system.
That's correct, yes, sir.
If I believe something, unless it is against public interest, morality or health, there cannot be any merit review or based on, my lord, rationality, science, etc., etc. Now, my lord, this my lord, view of my lord Justice Gajendra Gadkar, it is criticized by Mr. Sirvai. My lord, I'm very clear and I'm coming to that. We can cite Mr. Sirvai, we can cite Dr. Mullah, we can cite, my lord, D.D. Basu, but we cannot cite any random person, my lord. And that's going to be my argument on judicial review also in a limited sense. But please come to page 66, 67. My lord, this is what Dargah committee criticized by Mr. Sirvai. That is what I wanted your lordships to see. This is Sirvai's portion, my lord, in the book. It is submitted that the above obiter runs directly counter to the judgment of Justice Mukherjee in the Shirur Mutt case and substitutes the view of the court for the view of the denomination on what is essential a matter of religion. The reference to superstitious practices is singularly unfortunate. For what is superstition to one section of the public may be a fundamental religious belief to another, as my Lord the Chief Justice said.
That's correct.
Thus, for nearly 300 years, bequests for masses for the soul of a testator were held void as being for superstitious uses till that view was overruled by the House of Lords in so-and-so. It is submitted. My lord, then I'll go to the last highlighted part. The obiter of Justice Gajendra Gadkar in Dargah committee case is also inconsistent in observations of Justice Mukherjee in Ratilal Gandhi's case that the decision in Jamshedji versus Sonbai afforded an indication of the measure of protection given by Article 26B. Then, my lord, come Saidana Sahib, my lord. My lord, this is a subject matter which is specifically kept away. My lord, your lordships are going to examine this again, my lord, separately. But here, my lord, just to complete the narration of legal journey, I may point out, the question was that Saidana Sahib is the spiritual head of Daudi Bohra community called Dai, D-A-I, Dai. Lord Saidana Sahib or Honorable Dai has the power to excommunicate a person belonging to that religion, which would mean that he would not have any contacts with people from that religion, and my lord, he cannot get place in the for burial, etc., etc. There were several civil rights of which, my lord, he was deprived of. The Maharashtra government, my lord, brought an act somewhere, my lord, in 62. That, I'm sorry, 49, my lord, 49. It was challenged in 62, my lord, where they raised a contention. My lord, yeah, this is what, my lord Justice Bagchi also may examine. This was purely argument of 26-2. And court accepted that, and the result, my lord, I'm not going into the merits or rightness or my lord, judgment being right or wrong. The minority view of Justice B.P. Sinha said that no, you can't do something under 26B as a denomination which completely ousts somebody's civil rights and he becomes a non persona non grata. But the majority view accepted that no, 26B is a standalone provision. It does not say that denomination having right to uh, exercise their religious belief or control their religion would not be exercised in such a way that power of excommunication cannot be exercised. That was, my lord, the conclusion, because 26(2)B was read as an isolation, that it is not governed by any other provision. My lord, this
That is what I was telling you yesterday.
yes, my lord. Therefore, I said, my lord, that kindly see this may be the result. My lord, if 26B is not read with other fundamental rights, I, as a denomination, my worry is twofold. And this is my worry means the government's worry. Government is worried. Lord, there can be a denomination which says that we exclude women from all our religious institutions. We are not governed by 25. We are not governed by 14. We are not governed by 15. Lord, whether that would be a position which, while interpreting the constitution, your lordship, my lord, would like to do. But even within the community, my lord, a community, I am belonging to a community and I am not on Dalits or, my lord, earlier excluded categories. I belong to one community. My learned friend belongs to another community. My learned friend belongs to another community. My denomination would say it is a denominational temple. I prohibit his entry. His denomination would say, I prohibit his entry. Do we, my lord, take a view which results into fragmentation of the religion, my lord, on this line? If we read it under with 14 and 15, that no discrimination, and 17, Lord, then also, only, my lord, possibly, my lord, the 26B can be given its reasonable and purposive meaning. Lord, that is my respectful submission. Lord, now please see, my lord, the next judgment. My lord, here in Saidana case, they struck down the law that 26B gives exclusive jurisdiction to denomination to excommunicate anyone.
It was a law made under 25(2)B, is it not?
My lord, that was also rejected.
Social reform.
But, my lord, kindly see that now.
Excommunication. It was.
I'm obliged. Please come to page 671.
25(2)B and 26B. Ultimately, the court said 26B will prevail.
It will
They
not.
struck it down.
My lord,
They
kindly.
struck down that act.
No, they upheld that. They struck down that. Upheld the practice.
It was an act under 25(2)B. There's a reform.
Act was to prohibit the
Prohibit
practice, but
excommunication.
act was struck down.
Yes.
Correct, my lord. But upholding the excommunication right. But please come to page 71, since my ladyship has put this question, how the court deals with this 25 issue. Quite clearly, the only bold part, quite clearly, the impugned act cannot be regarded as a law regulating or restricting any economic, financial, political, or other secular activity. Indeed, that was not even suggested on behalf of the respondent state. It was faintly suggested, however, that the act should be considered to be a law providing for social welfare and reform. The mere fact that certain civil rights which might be lost by members of the community as a result of excommunication, even though made on religious grounds, and that the act prevents such loss, does not offer sufficient basis for a conclusion that it is a law providing for social welfare and reform. Your ladyship's observations were right. It could have been sustained as a principle of reform and social welfare, but it was said that it is not reform. The barring of excommunication on grounds other than religious grounds, say on the breach of some obnoxious social rule or practice, might be a measure of social reform, and a law which bars such excommunication merely might conceivably come within the saving provisions of clause B of Article 25. But barring of excommunication on religious grounds, pure and simple, cannot, however, be considered to promote social welfare and reform, and consequently the law, insofar as it invalidates excommunication on religious grounds and takes away thy power to impose such an excommunication, cannot reasonably be considered to be a measure of social welfare and reform. This is what the court said. Now, my lord,
They saved it under 26B.
B. Yes, my lord.
Justice B.P. Sinha, he struck it down.
Yes, minority structure.
Yes.
Is minority. He is minority. Now, the next judgment is, my lord, Govind Lalji Maharaj. That is, my lord, again, only one thing I'll say. This was filed by the Tilkayat, my lord, the Pujari of Vaishnavite temple. I'm not reading it, but the affected party approached the court. One of the questions, my lord, which is there, my lord, at page 76, my lord, the court again examines whether it is an essential religious practice or not. That's the reason, my lord, this judgment is placed.
Paragraph 57, are you referring?
Yes, my lord, 57. And they rely on Dargah committee and say that this particular practice we examine and say that it's not an essential religious practice. That's all. Well, I'm not reading it, but Dargah committee is followed, my lord. That is all, my lord, I wanted to show. Now, my lord, next judgment is page 78.
70?
78.
Raja Bira Kishore.
Yes, my lord, Raja, my lord, this was regarding Jagannath temple, Lord Jagannath temple, my lord, Puri, where again, my lord, the king, who was affected party because the management was taken over from him and was entrusted to a separate statutory body, my lord, came to, before this honorable court, my lord, which came to be challenged. My lord, again, my lord, the same law is applied, and therefore I have put it, my lord, I am not reading it. Then, my lord, next judgment also, my lord, I am not reading, my lord, except, my lord, to say, my lord, this is Digya Darshan Rajendra Ramdas Jivaru versus State of Andhra Pradesh. My lord, this is, my lord, now Justice Grover, Justice V. Ramaswamy, and A.N. Grover. My lord, please come to page 81.
Yes.
Para 10, only the bold part. The attack on the ground of violation of Article 25(1) can be disposed of quite briefly. It has nowhere been established that the petitioner has been prohibited or debarred from professing, practicing. That was, my lord, something on a totally different plank, my lord, which will not assist your lordships. Now, please come to the most important judgment, which is, my lord, Sheshamal, which is at page 81, at the foot. Look, this is, according to me, most important judgment for this reason.
Which one, Mr.?
82. 81. It starts at 81. Lord, it is Seshamal and others versus State of Tamil Nadu. Lord, here, look, there are, in all religions, this practice is existing. Succession by the Ustad to the Shagird, Guru to the Shishya. The mode of succession is prescribed. Lord, this was a Tamil Nadu temple. And there is a position of Archaka. Archaka, my lord, in our parlance, as my lord, other than Tamil Nadu, would means pujaris. Pujaris who would go to the sanctum sanctorum, they would deal with the deity, they would give bedding to the deity, they would change the clothes, they would do everything, my lord. And there was a provision in the belief system, faith system, and in the religious practice that Archaka would be hereditary, because one Archaka would teach the particular teachings, how to pray and worship the deity and how to perform the rituals to his Lord, son, etc., etc. Because precise mantras will have to be recited at particular times of the day, at particular events. Why, for example, when the deity is taking food, when deity is sleeping, etc., etc. So this goes from generation to generation. Now, and these are not, my lord, abstract propositions. Agamas provide for the detailed procedure which will be taught to his successor. My lord, this is called, my lord, the mode of succession. Now, my lord, the Tamil Nadu government enacted a law saying that no, we will appoint archakas, because appointment of archaka is a secular activity, though he might be conducting religious activities. Now, please see, my lord, how the court deals with, my lord. Lord, please come to page 85. Mr. Palkhiwala appeared, my lord, and I have read all his submissions, my lord. Obviously, my lord, I need not say, my lord, beautifully put. But this is, my lord, how the court is pleased to record, my lord. It's a correct recording of fact. I'm told Mr. Gopal Subramaniam's father also appeared in this matter. Lord, Mr. Palkhiwala, para 20, my lord, your lordships would get at page 85.
There is some highlighted portion before paragraph 20.
Yes, my lord, I'll read that first, my lord, then.
It is therefore manifest.
It is therefore manifest that the archakas of such temple, beside being proficient in the rituals appropriate to the worship of the particular deity, must also belong, according to agamas, to a particular denomination. An archaka of a different denomination is supposed to defile the image by his touch. No, this is not Dalit. This is not the practice of Dalit. Anyone else, my lord, other than the person, my lord, who is the archaka. He can be a Brahmin also, but not, my lord, this category of Brahmin. Defile the image by his touch, and since it is of the essence of religious faith of all worshippers that there should be no pollution or defilement of the image under any circumstances, the archaka undoubtedly occupies an important place in the matter of temple worship. Any state action which permits defilement or pollution of the image by the touch of an archaka not authorized by the agamas would violently interfere with the religious faith and practices of the Hindu worshipper in a vital respect, and would therefore be prima facie invalid and under Article 25 invalid under Article 25(1). Mr. Palkhiwala, on behalf of the petitioners, insisted that the appointment of a person to a religious office in accordance with the hereditary principle is itself a religious usage and amounted to a vital religious practice, and hence falls within Article 25 and 26. In his submission, priests who are to perform religious ceremonies may be chosen by a temple on such basis as the temple chooses to adopt. It may be election, selection, competition, nomination, or hereditary succession. Maybe, my lord, some qualified people are called, interviewed, and they are appointed, but it is a religious part of the religion and should be left to the denomination. That was, my lord, the argument. He therefore contended that any law which interferes with the aforesaid basis of appointment would violate religious freedom guaranteed by Article 25 and 26 of the Constitution. In his submission, the right to select a priest has an immediate bearing on religious practice and the right of a denomination to manage its own affairs in matters of religion. The priest is more important than the ritual, and nothing could be more vital than choosing the priest. Under the pretext of social reform, he contended the state cannot reform a religion out of existence. Please mark this. This is beautifully put. You cannot have a reform which puts the religion out of it. Court reform a religion out of existence, and if any denomination has accepted the hereditary principle for choosing its priest, that would be a religious practice vital to the religious faith and cannot be changed on the ground that it leads to social reform. Mere substitution of one method of appointment of the priest by another was, in his submission, no social reform. Then, my lord, next page, the board part.
In the name of social reform, the religion cannot lose its identity.
You cannot, yes, my lord, that's exactly, my lord, he says that you cannot, you cannot remove the existence of the basic core of the religion. Lord, now, Lord, page 72, I'm grateful to my learned friend. This is the, my lord, expression used by Justice Iyengar at page 72. Only 3 lines, my lord.
Page
72, 75, my lord, in the my lord, PDF. This is Sayyidna case, my lord. Yes. Lord, Mr. Palkhiwala's expression, the religion cannot be reformed out of existence, is borrowed from Justice my Lord Iyer. In my view, by the phrase law providing for social welfare and reform, it was not intended to enable the legislature to reform a religion out of existence or identity.
Cannot hollow it out.
Now, my Lord, in Sheshamal or Sheshmal, my Lord, it's Sheshamal. In Sheshamal, my Lord, I stand, my Lord, corrected. This is how, my Lord, the Honorable Court deals with. Para 21. It is true that a priest or an archaka, when appointed, has to perform some religious functions, but not some. The essential religious function of deity functions. But the question is whether the appointment of a priest is by itself a secular function or a religious practice. Mr. Palkhiwala gave the illustration of the spiritual head of a mutt belonging to a denomination of a Hindu sect like Shankaracharya and expressed horror at the idea that such a spiritual head could be chosen by a method recommended by the state, though in conflict with the usage and the traditions of the particular institution. Where, for example, a successor of a Mathadipati is chosen by the Mathadipati by giving him mantra diksha, or where the Mathadipati is chosen by his immediate disciples, it would be, he contended, extraordinary for the state to interfere and direct that some other mode of appointment should be followed on the ground of social reform. Indeed, this may strike one as intrusion in the matter of religion, but we are afraid such an illustration is inapt when we are considering appointment of archaka of a temple. The archaka has never been regarded as spiritual head of any institution. But he has more things to do with the deity than even spiritual head. He may be an accomplished person, well versed in the agamas and rituals necessary to be performed in a temple, but he does not have the status of a spiritual head. This is a wrong doctrine which is used. Wrong. Then again, the assumption made that the archakas may be chosen in a variety of ways is incorrect. The dharma karta or the shebiyat makes the appointment, and the archaka is a servant of the temple. It has been held in so-and-so versus so-and-so that even the position of the hereditary archaka of a temple is that of a servant, subject to the disciplinary power of the trustee. The trustee can inquire into the conduct of such a servant and dismiss him for misconduct. As a servant, he is subject to the discipline and control of the trustees as recognized by unamended section 56 of the Principal Act, which provides all office holders and servants attached to a religious institution or in receipt of any emolument or perquisite therefrom shall, whether the office or service is hereditary or not, be controlled by the trustee, and the trustee may, after following the prescribed procedure, if any, fine, suspend, so and so. Now, my lord, bold part. That being the position of an archaka, the act of his appointment by the trustee is essentially secular. So, the denomination cannot decide that may not be hereditary. We will prescribe certain qualifications requiring him to have knowledge of certain rituals, and thereafter we will have a transparent procedure of selecting the best. It's a secular activity. Your pujari,
Typically, they are not denominational temples. They are all public temples there.
that's not the ground which the court has.
Because
Your lordship knows, but the ratio is
who is to appoint them? Except that they come by the generation they come
Lord,
there.
even in a public temple, appointment of a pujari who requires certain expertise, qualifications, and knowledge of agamas can never be left to the government, my lord. A government of non-believers, for example, or a government of even believers cannot substitute. My lord, this tradition, it's a matter of faith and belief that this is how our religion has progressed. And we would trust only a particular person having a particular qualification and expertise to touch our deity.
But it need not be hereditary.
Need not be. Mr. Palkhiwala says that it need not be hereditary. It may be counterproductive. But I am not taking an extreme stand. It can be by selection that these are the qualifications you must have undergone, or there are courses for karma kand rituals.
That in Shashamal, the issue was whether they should be concluded on a hereditary basis.
Yes.
That was the issue there.
Correct, my lord. I am not defending hereditary.
Cannot be hereditary. That was the judgment.
Lord,
there.
I straightway concede.
While saying that, of course, they also said that it is a secular function and not a
That is
religious.
where the problem is. Another thing, even being a hereditary archaka, we may not like as secular people with the level at which your lordships, my lord, brilliance are examining, but it will have to be understood from the point of view and thinking process of those who believe, the adherents, that my deity cannot be touched by anyone unless he is qualified.
Anybody who is well versed in the agamas can be selected, is what the judgment says.
No, the denomination can say that we,
But it's
There is no
the
denomination
temple of
there. That's a difficult.
character.
my lord, let us not go by that particular temple. I am on principle.
See, we agree with you, as my sisters put it, whether the agama should be followed, in which way we have to prepare. These are all things we cannot go into. Only to extent that it cannot be by hereditary succession. That's to that extent we have to go by prima facie. We are saying they cannot go to the other extent of saying we will prescribe the agama how to do it.
The real
That may not be
problem is not, my lord, hereditary. Real problem is selection of pujari is a secular activity. That is the problem. Suppose the act would have said that no, we don't accept hereditary, but you provide for a transparent procedure for selection of agamas, provide for the
This has
qualification.
been answered in the case of Adi Saiva Sivacharya Sangam by this court in an elaborate manner. It discusses each and every aspect. So
Justice
that need
Go-
not be gone into too much.
No, my lord, last judgment in this series is, my lord, Adi Sheikh.
Use each and every aspect discussed in that judgment.
Your lordships are right. No, I'm grateful. Then, my lord, last, thus the appointment of an archaka is a secular act, and the fact that in some temples the hereditary principle was followed in making the appointment would not make the successive appointment anything but secular. It would only mean that in making the appointment, the trustee is limited in respect. A source of recruitment. Instead of casting this net wide for selecting a proper candidate, he appoints the next heir of the last holder of the office, that after his appointment of archaka performs worship is no ground for holding that the appointment is either religious practice. This is my problem. My lord, and this, my lord, may not be or may be true about that particular temple, but this is a law applicable throughout the country, that pujaris which require special qualification would now be appointed by the state government. You can have a law that follow this procedure, have the qualifications, transparency. Everyone should participate. But to say that no, we will make appointments because appointment is not a secular activity. My lord, this applies to even Mahant. The court is wrong, my lord, in saying that position of Mahant is different. If Archaka's appointment is a secular activity, appointment of a Mahant is also a secular activity.
That we can't say.
Yes.
Appointment of a Matadipati or Matadipati, that is not secular.
But Justice Ramaswamy, I'll show, my lord, that period of 96-97 has said it is also a secular part.
So that is why the mutts are excluded from the Religious Endowments Act. The mutts are excluded.
Wherever there is an act, my lord, we are taking all India thing. My lord, some states have religious endowments act.
Where the mutts are excluded from the.
Wherever there is a state law, all states do not have the law, and we are based more on principle. My lord, now please, Lord, come to SP Mittal.
There was some board.
यहाँ आ जा तू यहाँ आ जा पेज दें मुझे वो पेज तू इस तरफ आ जा ना Lord base, I'm sorry. Even Shankaracharya can be discussed. Huh? Can he not be? No. Shankaracharya. Oh. That's not sure. Wrong. You're quoted a page. Lord, even Justice Ramaswamy has, Lord, been pleased to go to the extent of saying Lord, my Lord Justice Ramaswamy, I'll show that, has gone to the extent of saying, relying upon this, that even Mahant or Mathadipati is also under the administrative control. He can be disciplinary, there can be disciplinary proceedings, he can be punished, he can even be removed. That's the problem. Therefore, I am starting with Sheshamal.
No,
And this would apply to all religious denominations.
a Mathadipati can also be removed, provided that such process of removal takes place within the sect itself.
Then, no, denomination. Yes, my lord.
There is
Yes.
nothing like that his misconduct is above law.
No. Cannot be. My lord, but it cannot be done under an act or by the state. My lord, tomorrow, my lord, by this very logic, I'm sorry to give this example, Shankaracharya can be removed by the state. Some archbishop can be removed by the state. This kind of things will have to emanate from the religion itself, from the society itself, from the denomination itself. It cannot be state controlled, my lord. That is the real secularism that state will not enter into. If we do not want religion to interfere with state, state also will not interfere with the religion. Para? Para. Board, but required to recognize the one paragraphic scheme. Except that I become That's properties. That's private. No. It's properties. No, it's not properties. मुझे एग्जैक्ट दिखा हुआ Yes. So, my lord, this is the danger, my lord. Your lordships are in a 9-judge combination, my lord. And the question is, my lord, would your lordships read 25 and 26, my lord, the way in which it is read in Sheshamal? Now, my lord, next judgment is page 89. My lord, that is, my lord, SP Mittal versus Union of India. My lord, again, an affected party came challenging an act of the state. Lord, this was a case, I'm sorry, my lord. Lord, page 89. Lord, this was a case of followers of Aurobindo. This is Auroville case, not Aurobindo case, but it is known as SP Mittal versus so and so. The affected party was here, and the question was, which, my lord, in my respectful submission, and I'm not, my lord, making it any complicated, it is a wrong law which is decided. The court decided what is the meaning and tried to define what is the definition as per the court of denomination. That, my lord, your lordships would find at page, my lord, Justice Chinnappa Reddy, my lord, dissented partly and concurred, my lord, partly. Please see, my lord, Justice Chinnappa Reddy's part dissent at page 91, only the bold part. If the followers, your lordship gets, if the followers of Sri Aurobindo constitute a religious denomination, as to my mind, they undoubtedly do, the members of Sri Aurobindo Society are certainly a distinct and identifiable section. Please mark this. This is the correct, my lord, interpretation. Denomination or a section thereof. Section of the religious denomination, the members of the society are followers and disciples of Sri Aurobindo. Now, my lord, majority is authored by Justice, my lord, Justice R.N. Mishra, and my lord, sorry, I stand corrected, my lord. It is my lord Justice R.B. Mishra. I'm thankful to Mr. Gopal Subramaniam. Lord, page 92, para 80. This is the definition which is followed in Sabrimala case. And in my respectful submission, irrespective of whether it is followed or not, this definition is an incorrect definition of denomination. And I will show how. The words religious denomination in Article 26 of the Constitution must take their color from the word religion. And if this be so, the expression religious denomination must also satisfy these three conditions. So must, and all three will have to be satisfied. First, it must be a collection of individuals who have a system of beliefs or doctrines which they regard as conducive to their spiritual well-being. That is common faith. Correct? This is the first definition. Common organization. And third, designation by a distinctive name. So the denomination must have a distinctive name. Now I want to give three examples, my lord, how this definition is wrong. My lord, take Dargah of Khwaja Moinuddin Chishti or Dargah of Nizamuddin Aulia. My lord, people of all religions go. They go with reverence. It will not fulfill the first condition that we all believe in that doctrine for my lord, fulfillment of our spiritual enlightenment. We go because we trust, we go because we have faith. Now, second, my lord, kindly bear also two other examples in mind. Shirdi, Sai Baba. All communities go, all religious people go. It's not clear whether Baba was belonging to Muslim or a Hindu religion, my lord. But every community goes with reverence. We all go. But we do not, my lord, have a collection of, we are not collection of individuals who have a system of beliefs or doctrine which they regard as conducive to their spiritual well-being. That is common faith. There is no common faith. My faith is Hinduism. My faith is Shaivism. My faith is Vaishnavism. My faith is Nastika. My faith is Shakti worship. But I go there. Third, common organization. There is no common organization either in Dargah, Khwaja Moinuddin Chishti Dargah, or for that matter, Balaji. Vaishnavites go, Shaivites go, Shakti worshippers go, and I have given several subsects. Everyone go. They have no common faith, but they go, they worship. There is no common organization. There is nothing like, my lord, Sai Babaist organization or Tirupati Balaji organization or something. There is no central organization and designation by a distinctive name. Lord, those who believe, those who go, those who pray, those who trust, and those who, my Lord, revere either Khwaja Moinuddin Chishti or Saint Peter, my Lord, in the church, or my Lord, for that matter, my Lord, Shirdi or Tirupati Balaji, there is no name of that organization. Would we not be a part of a section of denomination?
Mr. Solicitor, it is not denomination per se. It is religious denomination. How does it become religious denomination in the context of Aurobindo's philosophy?
Well, then,
Is the question.
the my Lord, question is, well, I'm putting a question to myself.
Philosophy, whether it is a religious denomination, does it lead to that?
It is a religious,
It is not denomination per se. Aurobindo philosophy is not a religion.
we are not on that distinction. I am not on that distinction. My Lord, it is religious. My Lord, we go to, my Lord, as a Hindu, when I go to, my Lord, Khwaja Moinuddin Chishti,
Please keep the, with respect, the illustration separate.
okay.
Let us see Aurobindo. Is that philosophy a religious denomination? It may be a denomination, but it can't be religious.
My Lord, that is,
Aurobindo philosophy, is it religion?
yes, it is religion. And again, my Lord, I'm kindly pardon me for saying this. This may be your ladyship's honest and informed view. But what is relevant is my view as a follower.
Followers.
Whether I believe that to be a religion. Well, that is where the judicial. Lord, Savitri is written by Aurobindo.
We appreciate your argument is that because the Arvindo's followers believe
Yes.
that that the view which they follow is a religious view, or it carries all the ingredients or the components of a religion. Therefore, they themselves carve out to be an exceptional or a separate religious denomination.
Or a section thereof. Or a section thereof.
And therefore, the others cannot impose on them that no, you are not a religious.
You are not a denomination.
Arvindo, I follow in my right from the morning I get up till I sleep. I follow his ideas, his philosophy, his guidance, and whatever I treat him as my everything, including the supreme will. Therefore, who are you to tell me that I should not follow Arvind? This is what the kind
And-
of.
See, it can come under freedom of conscience, but it cannot come under a religious denomination.
It would be a religious denomination, Lord, because otherwise under 26B, Lord, there can be a restriction imposed that for this particular followers, this thing will not be permitted. The state can say. And therefore, my Lord, the question is not question of ego. Question is of fundamental right.
This denomination is the question.
My Lord, religious denomination would mean
Mr. Solicitor, perhaps you are applying the tests to the wrong group. You are applying the tests to the persons who are visiting the organization, the temple or institution as a mutt. But where the test is to be applied as per this ratio is the organization of the group of persons who are managing the temple or managing the mutt, whether they have a common faith, whether they have a common organization.
So if they have been elected by the followers of the mutt and they themselves are followers, they are bound to be. That is what probably the viewpoint.
my Lord, what is the problem is this? I'll tell, straightway come to the problem.
See why the test should apply to the management of the persons organizing it. That is where the answer of common organization will come. And anyone who is coming to the temple is a part of the common faith. That is
Need not be. My Lord, I would respectfully disagree.
just clarifying that to you. It may be a part of the common faith that other believers may also come to our institution. It can also be a part of the common faith that apart from my believers, nobody will come to the organization.
No, my
The
Lord,
test of religious denomination in Auroville was not decided primarily on the lack of uniqueness or commonality. it was decided on the widest berth of the definition of what Hinduism is. And that is where you have made out a case that the courts should not go into the question
And
of
my
what
lord,
Hinduism is.
Lord, what
But
Hindu is,
there has been a series of judgments.
Lord, I have to answer.
It's been considered to be of such wide plank that any interpretative or even reformist philosophies have fallen within the fold of Hinduism and therefore not been treated
My
as a
lord,
part
the
of the
first question, my lord, and kindly pardon for this question.
It starts from Aurobind. It starts from Swaminarayan case. In Swaminarayan case, that Yoga Purush.
Yeah, Swaminarayan sex is not considered to be.
Issue.
Lord, can I answer now? Can I answer?
Samir and Narayan, and they, unlike Aurobind, to the best of my knowledge, Aurobindo is never worshipped as God. But
Lord, that is your lordship's
no,
view. I am on the view of the follower.
Nowhere in Savitri or any of his writings does Aurobindo define or propose to his followers as God. What distinction I'm trying to make is in Swaminarayan, the followers consider Swaminarayan as God. Still then, Justice Gajendra Katkar does not hold his as
It is, Lord, we are not saying, nobody says that Aurobindo or Swaminarayan for that matter is a religion. It is a denomination which is a section of
right.
this. Lord, second, Lord, another thing. Lord, your lordship's understanding of religion with your lordship's scholarship of law and religion, Lord, in some cases, maybe that and may even be correct. Would it be a correct test to be applied for my fundamental rights? Your lordship's, Lord, level of intellectual scholarship may be different. Your lordship's knowledge and reading of Savitri may be different. It is, my lord, my understanding as a follower, my lord, will be the real test to decide whether we fall within a section of the denomination. We means, my lord, I'm just giving my example. And my lord, some say Savitri is a philosophical document. Some say it is for spiritual and Lord, enlightenment. And some say it is, my Lord, just preaching and not. And nobody has elevated themselves to the level of God. Krishna never said, my Lord, that I am the God and worship me. We worship the Lord Krishna. Aurobindo would never say that, please worship me. Sai Baba never said that, please worship me.
You don't have an idol of Aurobindo in Aurobind.
Yes.
You have an idol of Swaminarayan in Swaminarayan temple.
Lord, I understand.
The distinction.
I understand, my lord, but in my respectful submission.
Need of an idol to follow.
Yeah, yeah.
The point is that probably 25, 26 are to be examined in the light of the constitution granting constitutional protection to religion, to religious bodies or religious denominations.
Or a part, section.
And that protection has to be seen from the angle that if there is an aggression or action by the state to intervene in that, then how to protect these categories?
But only one more examples, kindly allow me to give. Arya Samaj and Brahmo Samaj. There are never any idols. They are against idol worship. There is a separate theory. They are against Vedas also. But they are a denomination. There is no, my lord, common faith or belief because they are against faith and belief. They are against faith and belief. That is their faith or that is their belief. And there is no common organization or common name. I can be an Arya Samaji without being a member of Arya Samaj. People who believe staunchly in Hinduism go and perform religious rituals as per Arya Samaj, my lord, rituals, which is, my lord, very, very small and ritualistic. So, my lord, these are the issues. The question is, would the court go into and define, my lord, in such a way, which is, we are trying to define undefinable. We are trying to define, my lord, religion. We are trying to define denomination. And then we are trying to define what is a religious denomination. And if it doesn't fall within these three tests.
It doesn't say yes there. Madam Chief has said, this is one of the few conditions required. When you interpret the definition, when you give definition of religious denomination, what Madam Chief is saying is given a wider import. so that they will get the benefit of Article 25 and 26 is what,
Sir,
that's a correct view.
Lord, the
He has
difficult,
rightly said 26 will say 6 thereof. So like you may be a believer in Lord Vishnu. You can go to Tirupati. You can go to other temples. There also you can have different subsects there. There may be the Devasana will be there, the other sects will be there. Each one will constitute a religious denomination. Therefore, they are entitled for protection. That's what Harvasi is saying. So to have a very restrictive meaning on this,
Basically,
Ah,
and
yes.
any majoritarian. or-
any identifiable group
will purport-
having the
we have
common
to see
faith
what
will
is
have the
purport of
protection.
Constitution makers behind
yes, sir.
25, 26, that's all.
yes,
To have
that's,
a
Lord, that's,
and,
I leave it at
Mr.
that.
Mehta, you just quoted Ajmer Dargah Sharif. It is a denomination. It is a part of a section of religion because basically it's Islam, it's a Sufist thought, and they practice. How do you say it comes out? It gets the protection.
I'm not saying, I'm sorry.
You said that it was outside, anybody can go, doesn't mean that it goes outside the purview of a broad denomination of a religion.
Lord, kindly, I could not, Lord, make it clear to your lordships. Kindly see the definition, this straitjacket definition in the context of Ajmer. I'm not saying it's not, it is a denomination. It is my case. It is not fulfilling this straitjacket test.
we take it that it should be read down to mean the other factors also.
Yes, my lord.
Don't feel that that's no problem.
So,
That's
my lord,
also,
for example, take my lord, page 92.
Yes.
Satisfied. It is my case that it is denomination.
Yes, sir.
But it will not fulfill this test because the
It's a
test is
facility we
wrong.
can take it. Along with the country.
Kindly see, my lord.
No,
What is
Mr.
the test?
Mr. Mehta, again, a doubt has arisen in my mind. Kindly, all of you will clear it. Why are we trying to interpret Article 25, 26, where the language is very clear? Unless a particular, all these cases related when a fact came before, whether that fact would be covered by 25, 26. But say there's no dispute.
I'll
that
give an answer.
What is the level of protection, to what extent, and in what nature of activity? Unless we have that in focus, I think there's no dispute of anybody either this side or that
Well,
side.
there is a dispute, and I'll tell
We're
your
not
lordship.
able to make out what that, without
I'll
the
just
factual
point. I'll
aspect,
just point out.
what will be that dispute?
I'll just point out, my lord, why this has emanated. It's not just in an academic sphere that we are arguing. In Sabrimala judgment, the court has examined this definition and said that those who go to Ayyappa temple do not fulfill these three tests, and therefore it is not a denomination.
Got it, sir. We appreciate it.
Therefore, this question has arisen.
You're right. Then we have to deal it specifically with regard to the Ayyappa temple, not Ayyappa temple. Just general, the law is there, the
But they have
constitution is there. What
given
are
a
we-
definition for everyone to follow.
So we take it as illustrative. Your argument.
Your lordship, sir.
What is abstract?
Yes.
We appreciate it. Yes.
Lord, then your lordships may kindly come to, I'm not reading it, page 93, the first Anand Margi case, my lord. That may not have much, my lord, for your lordship's assistance. Then, my lord, Bijoy Emmanuel case. Lord, there your lordships may come.
Anand Marg only para 11 is relevant, page 95, that's all.
Your lordship.
But Mr. Solicitor, Anandamarg case is very interesting because while in Auroville they hold it's not a religious denomination, in Anandamarg they hold it is a
Exactly.
religious.
And Swami Narayana, some
That's where the dichotomy comes.
dichotomy comes, my lords. And, my lord, it should be,
Because if you hold Anandamarg case correctly decided, then Auroville requires to be.
overruled. Yes. Well, in Anand, in this Anand Margi case, they hold that it's not a separate religion, but it is a denomination. So completely a contrary view.
By all the three conditions, therefore they say it here.
That's, so,
Yes,
Lord, Anand Marga, para 11 at page 95, Anand Marga appears to satisfy all the three conditions. So now, my lord, we are in the zone of three straitjacket conditions. You have to follow 1, 2, and 3. If you do not follow, you are out. Now, my lord, second is Bijoy Emmanuel case, my lord. My lord, this was singing the national anthem, my lord, by those who believed in Jehovah's Witnesses. My lord, the originalistic view of Bible. That is, my lord, Jehovah's Witnesses. That Bible should be read as it is. Yes, I'm saying. My lord, when national song was being played, those who believed as Jehovah's Witnesses, they say, will not stand. because as per our understanding of our scripture, that is prohibited. Now, please see page 97, the bold part.
National anthem.
Yes.
It's the national anthem,
I think
not national song.
We do not endorse the view
We do
suggested.
endorse. We do endorse. Not is not there.
We do endorse, I'm sorry. We do endorse the view suggested by Davar J's observation that the question is not whether a particular religious belief or practice appeals to our reason, that is the judge's reason, or sentiment, but whether the belief is genuinely and conscientiously held as part of the profession or practice of religion. Our personal views and reactions are irrelevant. If the belief is genuinely and conscientiously held, it attracts the protection of Article 25, but subject, of course, to the inhibitions contained therein. Well, this is the correct statement of law in my respectful submission. Then, my lord, next page. This sentence, my lord, then it my lord, refers to the earlier judgment and says that, my lord, very politely, my lord, they were lesser strength, numerical strength was less. Two judge, my lord. Therefore, they do not say that 5 judge is wrong, my lord. This sentence appears to have crept into the judgment by some slip. It is not a sequitur to the reasoning of the court on any of the issues. In fact, in the subsequent paragraphs, the court has expressly proceeded to consider the claim of Anand Marga to perform Tandava dance in public streets pursuant to the rights claimed by them under Article 25(1). My lord, then comes, my lord, era of Justice K. Ramaswamy, the third era, my lord, which I have said, my lord, starting from Justice B.K. Mukherjee, then my lord, Justice Gajendra Gadkar. Now, this is the third era. My lord, my learned friend, I discussed with him, my lord, so that I can skip it. He is going to, my lord, show this. Therefore, my lord, I am not relying upon it. But all 4 judgments, all, my lord, 5 judgments, my submission is, are wrong and not as per either Serur Mutt or based upon true construction of Article 25 and 26. And all are benches of lesser numerical strength. 2 judges or 3 honorable judges. My lord, the learned amicus is, my lord, going to place it. So, my lord, I'm saving my time. Kindly come to 117. My lord, this is a judgment. 118. Lord, now second Jagannath temple case. Lord, again, the person aggrieved, the Jagannath temple Puri management came. Lord, I am not reading, my lord. It is substantially on the same wrong line, my lord. That's all I would say. Now directly come to, my lord, page 121, John Vallamatam case. Honorable 3 judges. I'll read only, my lord. Just above para 41, the petitioner, your lordship gets, my lord, page
yes,
122. The petitioner has not been able to place any material to show that disposition of property for religious and charitable purposes is an integral part of Christian religious faith. Disposition of property may perhaps not be, my lord. 42. Article 25 merely protects the freedom to practice rituals and ceremonies, etc., which are only the integral parts of the religion. Article 25 of the Constitution will therefore not have any application in the instant case. My lord, thereafter, my lord, Nellore Marthadam case, my lord, I am not reading it, my lord. Question was whether a temple is a denomination or not, my lord. Nothing may, my lord, further assist your lordships. Then comes, my lord, second Anand Margi's case. And, my lord, I would like your lordships, my lord, to consider the minority view of Justice Lakshmanan.
Which page, Mr. Solomon?
Lord, page 124.
In the second Anand Margi.
Second Anand Margi case, my lord, at page 125, 128, my lord, for the PDF pagination. Lord, this is, I must, my lord, repeat it at the cost of repetition, say, I'm reading the minority view first. But before a 9 judge, my lord, that makes no difference. My lord, paragraph 55. I shall now consider whether Anand Margis have the fundamental right under Article 25 and 26 of the Constitution. My lord, page 125, para 55. Minority view of my Lord Justice Lakshmanan.
Oh, yes.
Para 55, your lordship gets. I shall now consider whether Anand Margis have the fundamental right under Article 25 and 26 of the Constitution. Anand Margis are a religious denomination and as such are entitled to the protection under Article 25 and 26b of the Constitution for their beliefs and practices, including their practice of Tandav dance in procession or public place. This is because, as held by this court in several cases, religious practices or performances of acts in pursuance of religious beliefs are as much a part of religion as faith or belief in particular doctrines. No outside authority has any right to say that these are not essential parts of religion, and it is not open to the secular authority of the state to restrict or prohibit them in any manner. My lord, then in the bottom, the bold part.
I still understood that.
Further, in exercise of the power to regulate, the authorities cannot sit in judgment over the professed views of adherents of the religion and to determine whether the practice is warranted by the religion or not. Even state cannot do that. 10 religions and sub-religions, sub-denominations, whether it is Hindu, Christian, Muslim, Judaism, whatever.
Subject to 3 areas, public morality.
Of course, yes, my lord, if it is against public, that is, my lord, of course. Then, my lord, para 60. My lord, and this is important, my lords, because this would have a bearing on one of the questions framed by your lordships. What is the meaning of morality under Article 25? Whether it is societal morality or a vague and wrongly applied definition of constitutional morality. Please see, my lord, para 60. Moreover, public order has a larger connotation than law and order. Contravention of law to affect public order must affect the community or the public at large. A mere disturbance of law and order leading to disorder is not one which affects public order. But I'll show the judgment which says that public order, morality, and health is understood to mean public order, public morality, public health. It cannot be, my lord, some vague concept of constitutional morality.
You cannot make public health. It has to be individual.
Health can individual, but it cannot be only individual. It cannot be only individual.
We understand your borrowing public for morality.
Under Article 19(2), it is decency or morality.
2 and 4, 19.2, 19.4. And I have cited judgments. Therefore, I am quickly going through this.
Broader than constitutional morality.
Exactly. Constitutional morality can
Describe-
neither be, my lord, restrictor or broader because it has no existence under the constitutional scheme. Constitutional morality, I'll come to that as a separate chapter, is, my lord, a doctrine of political science, how functionaries are to function. Whether a person who is facing a serious criminal charge should step down or not. These are constitutional conventions which are described as constitutional morality. It is not, my lord, one of the grounds to exercise judicial review. Judicial review will have to be exercised as per constitution. If it is public order, morality, and health, you have to go by only public order, public morality, and public health or individual health. But the Sabrimala says that we will not go by the societal values and societal morality because that is mob morality. And we will go by the constitutional morality. So if I say something that this is my faith, this is my belief, and
The point of view.
this is my faith, This is my belief, and this is not harming the society. None of them have any objection. They would merely be a mob. The court would decide whether it is a constitutional morality or not. Well, I'm putting it little, Lord, in a harder way, but it's that, Lord, respectfully absurd. Lord, now para 65.
Public
This
morality is from the point of view of the followers,
follows.
this case, followers of that.
Yes, but and maybe public at large.
Yes.
Maybe public at large, my lord, sir.
Constitutional morality is constitutional dharma.
That's the word, my lord. That constitutional dharma of functionaries, how government should function, how functionaries should function. If there is absence of constitutional provision, what are the conventions, constitutional conventions? But
Mr. Solicitor, you are perhaps saying that constitutional morality governs secular life and the capsule of religious rights have to be on the basis of understood morality of society vis-a-vis the religious tenets followed by a particular
I'm grateful.
denomination or
I'm grateful, my lord. That is
So
what
the secular character of the citizen and the religious belief of the citizen cannot be merged in a secular democratic.
or tested based on one condition, that is constitutional morality. If otherwise, it is socially moral and acceptable to cultural ethos of this nation,
Which you say as societal morality.
societal morality.
Put it differently, public order, morality or health, maybe a species or pieces of the genus of constitutional morality.
Lord,
But it cannot constitute constitutional morality as such.
correct, my
You
lord,
can't
but
pitch it so high.
Lord, I am going,
It can be fitted into the.
your lordships are right, my lord. For my purpose, that's, my lord, enough. But I am going to, my lord, I am before a 9-judge bench, suggest that constitutional morality is never a ground of judicial review. And our, my lord, I can quote our former Attorney General, who is a jurist in his own right. He has delivered a lecture that constitutional morality is an unfortunate thing. Better it dies sooner.
That's a very.
Anyway, my lord, page para 65.
Sometimes it is very subjective, that's why.
It's very subjective. My lord, something which is as per constitutional morality for one honorable judge may not be constitutional. So therefore, you can't exercise judicial review on vague terms.
Solicitor, the word of Article 25(1) is conscience.
Conscious.
So if it's the conscience of a particular section of citizen to be governed by constitutional morality, so be it. But that does not mean that section of citizen is going to have its imprint over the conscience of another groups and sections of citizens whose morality may be of different standards, but within the expansive, elastic idea of the society of the day.
My lord, now, my lord, my lord, the page is para 65. This court has explained in a number of decisions that what constitutes an essential part of a religion is primarily to be ascertained with reference to the doctrine of that religion itself, and the court cannot say that a belief or practice is not part of the religion. The proposition was authoritatively laid down by the Constitution bench of this court, 7 judges in Sirur Math, as extracted in paras supra. This is the most essential part of fundamental rights of freedom. Now, my lords, may kindly come to para 80 on the next page. Lord, this is, my lord, Justice Lakshmanan quotes Justice Gajendra Gadkar, Bijoy Emmanuel case, and my lord, this is his critic, if I may use the word, para 80. Here, the court has assumed the role of a theologian after making a roving inquiry. While the decision is criticized on the ground that once this door is opened, there is no limit to which the court cannot go. The answer is that the power of judicial review as a part of the basic structure is vested with the court, and if someone has to be trusted, let it be the courts even in matters of faith. This court, as stated earlier, considered the question whether performance of Tandava dance is a religious rite or practice essential to the tenets of the religious faith of the Anand Margis. The court, while upholding, my lord, thereafter, my lord, I am not much, my lord, saying, my lord, then Subramaniam Swami case, My lord, I am not taking your lordship through. Then Adi Saiva case, my lord, as my lord Justice Mahadevan, this is the last in line. My lord, Adi Saiva was authored by Justice Gogoi. Why I am saying, thereafter Justice Gogoi was confronted with this review in Sabrimala. And Justice Gogoi was aware that right from Serur Math till date, there are several judgments which are taking some views here, some views there, and therefore, in the reference, his lordship uses that there has to be evolution of a judicial policy. How would we deal with 25 and 26? Lord, kindly have a look, my lord. Para third,
Yes.
my lord, page 132, para 38. All these previous judgments, my lord, are considered, cited, opined. The ecclesiastical jurisprudence in India sans any specific ecclesiastical jurisdiction revolves around the exposition of the constitutional guarantees under Article 25 and 26 as made from time to time. The development of this branch of jurisprudence primarily arises out of claimed rights of religious groups and denominations to complete autonomy and the prerogative of exclusive determination of essential religious practices and principles on the bedrock of constitutional guarantees under Article 25 and 26 of the Constitution and the judicial understanding of the interplay between Article 25(2)(b) and 26(b) of the Constitution in the context of such claims. Then, my lord, court quotes Serur Math, my lord, and kindly now come to, this is the last judgment, my lord, I am reading on this. Then I'll come to Sabrimala at a relevant point of time after answering the questions or while answering the questions. 44. My lord, this is for the first time this honorable court has examined neither in Serur Math till date, Article 16 sub-Article 5 was taken note of or was argued, was not even argued. That's what my lord, his lordship says. Article 16(5), which has virtually gone unnoticed till date and therefore may now be seen, is in the following terms. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with affairs of any religious or denominational institution or any member of governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Lord, none of the judgments takes note of this. A plain reading of...
It came into effect only in 2000.
Pardon?
It is amended. Article 16 was amended in the year 2000.
No, my lord, I think it was there. It was an original provision. It's an original provision subject to, my lord. Lord, it is an original provision, my lords.
What was amended is only 6.
So 4A, 4B was introduced. The number changed. My lord, number changed.
5 remains the, or 5 is the original one.
No, my lord, I am sorry. 5 has remained the same. Even number has not changed.
The original one.
6 is new addition. 6 is, your ladyship's impression is about 6. 4A, 4B and 6. 15 has always been there. So it is missed, my lord. It's a responsibility, my lord, on our side. We may not have, outside of the bar, my lord, we may not have pointed it out. A plain reading of the aforesaid provision, that is Article 16(5), fortified by the debates that had taken place in the Constituent Assembly, according to us, protects the appointment of archakas from a particular denomination, if so required to be made by the agamas holding the field. The debates in the Constituent Assembly referred to disclose, well, that is on 16(5), which I have not read, but we can go by, my lord, the formulation of his lordship, my lord, should be restricted to appointment in offices connected with administration of a religious institution was negative. The exception in Article 16(5), therefore, would cover an office in a temple which also requires performance of religious functions. In fact, the above thought not expressly stated above, though not expressly stated, could be one of the bases for the views expressed by the Constitution bench in Seshamal. The court was, my lord, in a combination of lesser numerical strength.
But
It's
they are actually militating against your argument. Justice Gogoi using Article 16, Clause 5 to imprint on the constitutional imprimatur of the secular character of religious.
please read further, my lord. Please read further, my lord. Para 47. The issue of untouchability raised on the anvil of Article 17 of the Constitution stands at the extreme opposite end of the pendulum. Article 17 of the Constitution strikes at the caste-based practices built on superstitions and beliefs that have no rational or logic. My lord, we fully agree with this. The exposition of the Agamas made a century back by the Madras High Court in Gopala Mupnar. My lord, yesterday, my lord Justice Sundaresh asked, my lord, I said, this is the judgment, my lord. But I'm not reading it, my lord, it would become very long. Agamas made by so-and-so, that exclusion from the sanctum sanctorum and duties of performance of pujas extends even to Brahmins is significant. The prescription with regard to the exclusion of Brahmins in Gopala Mupnar, so-and-so, has been echoed in the opinion of Sri Parthsarthi Bhattacharya as noticed by the Constitution bench in Seshamal. Such exclusion is not on the basis of caste, birth, or pedigree. The provision of Article 17 and Protection of Civil Rights Act, therefore, would be of no much significance for the present case. Then 49. The difficulty lies not in understanding or restating the constitutional values. There is not an iota of doubt on what they are, but to determine whether a claim of state action in furtherance thereof overrides the constitutional guarantees under Article 25 and 26 may often involve what has already been referred to as a delicate and unenviable task of identifying essential religious beliefs and practices, sans which the religion itself does not survive. It is the performance of this task that the absence of any exclusive ecclesiastical jurisdiction of this court, if not other shortcomings and inadequacies, that can be felt. That this is not possible for this court because we are not having that jurisdiction and we do not possess. Sometimes even we believe we possess. We do not possess the knowledge of religion. All of us, my lord, with a varying degree, we have the knowledge of religion, which is only maybe 1% of what actually the religion is. Anyway, my lord, then the last, my lord, highlighted part, the exclusion of all outside authorities from deciding what is an essential religious practice must be viewed in the context of the limited role of the state in matters relating to religious freedom as envisaged by Article 25 and 26 itself, and not of the courts as the arbiter of constitutional rights and principles. Then, my lord, last, in this regard, it will be necessary to re-emphasize what has been already stated with regard to the purport and effect of Article 16.5 of the Constitution, namely the exclusion of some and inclusion of a particular segment or denomination for appointment as archakas would not violate Article 14 so long as such inclusion or exclusion is not based on the criteria of caste, birth, or any other constitutionally unacceptable parameter. My lord, this I have, my lord, a reservation, my lord, partly. Now, my lord, I'll come to, my lord, my submission.
You have reservations on other constitutionally unacceptable parameters.
Yes, my lord.
That is probably the portion which you have.
25 has its own, my lord, parameters on which, in will of which, you will judge the fundamental rights. Lord, now, my lord, I'll come to the submissions and I'll take, my lord, interplay between 25 and 26 last, because otherwise I'll not be able to complete other, my lord, because there would be some, my lord, assistance called for by the court, my lord. So I'll start with another, my lord. My lord, we have already submitted But it is already filed, my lord, but the copies, my lord, I can hand over. And your lordships can rest assured, I'm not going to read every part of it. I have marked yesterday what is to be skipped and what is to be there. I'll just give, my lord, the flavor.
This is which volume?
My lord, this is 1.5, Roman 1 point numerical 5. Hard copy, है? It's in the chamber. Lord, please come to page 40 first. Lord, 25, 26, I'll be doing last. I have substantially, my lord, I have answered, but there, my lord, there might be some assistance which your lordships may, my lord, more assistance required, my lord. Therefore, I'll start, my lord, from page 40.
Question number 4.
Yes, my lord, questions of the court, my lord. What is the scope and extent of the word morality under Articles 25 and 26 of the Constitution of India, and whether it is meant to include constitutional morality? Now, my lord, there is an intrinsic guidance in the Constituent Assembly debates as to how the expression morality,
Yes.
I'm sorry, but it's question whether it's constitutional, its morality means constitutional morality or public morality or societal morality. Lord, there is an intrinsic guidance in the debates of the Constituent Assembly how the framers framed this particular clause. My lord, that is at page 41. Mr. Z.H. Larry. I would like to point out in this connection the various security acts which have been passed by various legislatures, particularly the Safety Act in one province, which even excluded the right to move the High Court under section so-and-so. The second admission that he made is constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people have yet to learn it. Well, the detailed debate says that constitutional morality means constitutional conventions, how constitutional functionaries would behave. And Dr. Ambedkar said that we are a new nation, we have just been born. This will have to be cultivated amongst the people, that how they would act as citizens, how functionaries would discharge their functions, etc. I say not only the people, but even the governments have to learn it. To prove this, I will cite only two instances. The House will remember that in Calcutta, in Bengal, the High Court was seized of a case and had appointed a full bench to decide as to what is the effect of the word reasonable in an enactment dealing with government's power to arrest and detain. The bench was to meet only next day, but the government came out with an ordinance laying down that the word reasonable shall be held to have been deleted. No doubt, as the High Court remarked in that case, His Excellency the Governor of the province was fully within his rights to enact an ordinance, but it was against constitutional morality. This is the meaning of constitutional morality. How constitutional functionaries deal with other constitutional functionaries or citizens or other statutory authorities when a democracy, a republic is born. My lord, then I'll not, my lord, now come to para 141. It is submitted that a closer look at Constituent Assembly debates makes it clear that the word morality in Article 25 was envisaged to be public morality by the framers. My lord, why I am, my lord, taking, my lord, little time? Sabrimala continuously, my lord, proceeds on the ground that morality doesn't mean social morality. Social morality is only mob. What is necessary is constitutional morality. And therefore, my lord, I am emphasizing, as understood by the framers of the Constitution, morality is societal morality, something which is acceptable to cultural ethos of the country. The Honorable Sri Santhanam, Mr. Vice President, sir, I stand here to support this article. This is Article 25. This article has to be read with Article 13, Article 13 has already assured freedom of speech. 13 means present 19. Freedom of speech and expression, and the right to form association or unions. The above rights include the right of religious speech and expression and the right to form religious association or unions. Therefore, Article 19 is really not so much an article on religion freedom, but an article on what I may call religious toleration. It is not so much the words all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion that are important. What are important are the governing words with which the article begins, that is, subject to public order, morality, and health. Hitherto, it was thought in this country that anything in the name of religion must have the right to unrestricted practice and propagation. But we are now in the new constitution restricting the right only to the right which is consistent with public order, morality, and health. The full implication of this qualification are not easy to discover. Naturally, they will grow with the growing social and moral conscience of the people. For instance, I do not know if for a considerable period of time the people of India will think that Parda is consistent with the health of the people. Similarly, there are many institutions of Hindu religion which the future conscience of the Hindu community will consider as inconsistent with morality. Morality is understood in the context of societal morality, that society will evolve and the concepts of morality will change with evolution of each generation. Well, that is the expectation. Now, my lord, how, my lord, the word morality, as your ladyship, my lord, pointed out, is used in Article 19. Please come to, my lord, Keshavanand Bharati. This is how, my lord, the word morality is used even by 13 judge bench, which is not, my lord, referred to in Sabarimala. But, my lord, please see Justice Palekar's view in, my lord, what he understood, his lordship understood to be public order and public morality. Please see, my lord, the highlighted part. Even the rights conferred are not in absolute terms. They are hedged in and restricted in the interest of general public, public order, public morality, security of the state, and like, they were discussing 19. And therefore, my lord, public morality, security of the state, and the likes, which shows that social and political considerations are more important in an organized society. So when the word morality is used in Article 19, it is understood as public morality by a 13 judge bench. Lord, kindly now see K.A. Abbas versus Union of India, the relevant part at page 44. Para 39. It therefore follows that the American and British precedents cannot be decisive, and certainly not the minority view by some of the judges of the Supreme Court of the former. Please mark this. I would show something, my lord, very relevant, very important, and a part of the question which is posed by framed by your lordships. Minority, first of all, foreign judgments can never influence our adjudication, but relying upon minority view of foreign judgment, my lord, is frowned upon. Former. The American Constitution stated the guarantee in absolute terms without any qualification. The judges try to give full effect to the guarantee by every argument they can validly use. But the strongest proponent of the freedom, Justice Douglas, himself recognized in Kingsley case that there must be a vital difference in approach. Lord, Justice Douglas quotes our constitution. Now we have the era where we are relying upon very reverentially the foreign jurisprudence. Please see what Justice Douglas says. If we had a provision in our constitution for reasonable regulation of the press, such as India has included in hers, there would be a room for argument that censorship in the interest of morality would be permissible. Now, this was the era where we were being cited by other jurisdictions. It would appear from this that censorship of films, their classification according to age groups, and their suitable for unrestricted exhibition with or without excisions is regarded as a valid exercise of power in the interest of public morality, decency, etc. This is not to be construed as necessarily offending the freedom of speech and expression. This has, however, happened in the United States, and therefore decisions, as Justice Douglas said in Tagore Law Lectures, have the flavor of due process. That is their equivalent of Article 14, rather than what was conceived as the purpose of the First Amendment. This is because social interest of the people override individual freedom. Sabrimala says exactly contrary to this, that individual freedom, dignity will take precedence over social interest, because what is societal morality is merely mob morality. Then last, my lord, highlighted part, the larger interest of the community require the formulation of policies and regulations to combat dishonesty, corruption, gambling, vice, and other things of immoral tendency and things which affect the security of the state, etc. So what was considered was immoral society deciding whether it is socially immoral or cultural ethos permit it or not. Then, my lord, Murlidhar Agarwal, para 32, the judges are to base their decisions on the opinions of men of the world as distinguished from opinion based on legal learning. In other words, the judges will have to look beyond the jurisprudence, and that in so doing, they must consult, please mark, not their own personal standards or predilections, but those of the dominant opinion at a given moment, or what has been termed customary morality. It's not individualistic, subjective morality, and constitutional morality, by definition, inevitably is subjective morality. Then, my lord, similar, my lord, is in state of Maharashtra versus Indian Hotel and Restaurants Association. But please see page 148. My lord, I am not reading page 1 for para 147, the judgment of your lordships, my lord, where again morality is used as societal morality. But please see Indian Hotel and Restaurant Owners Association, para 79. It needs to be borne in mind that there may be certain activities which the society perceives as immoral per se. It may include gambling, though that is also becoming a debatable issue now, prostitution, etc. On the other hand, what I'm reading at the bottom, obscenity is treated as immoral. Therefore, obscene dance performance may not be acceptable, and the state can pass a law prohibiting obscene dances. However, a practice which may not be immoral by social standards cannot be thrust upon the society as immoral by the state with its own notion of morality, and therefore exercise social control. Furthermore, and in any case, the legislation of this nature has to pass the muster of constitutional provision, etc., my lord, to which I have no difficulty. My lord, I have given judgments on morality, which I am not, my lord, repeating. My lord, can I start?
Whatever has been said has been diluted by these last two lines. Furthermore, in any case, any legislation of this has to pass the muster of constitutional provisions as well. But does it not dilute whatever has been said earlier?
I am on the point that morality is social morality. I am not whether state can impose A or B.
That every legislation has to.
Lord, every law, whether on morality or not, will have to pass constitutional muster. Lord, there, you don't need a judgment for that proposition. Lord, may I start, my lord?
Quickly, with the passage of time in Indian society, what was considered to be immoral or obscene, no longer considered immoral or obscene. That is the problem of India now.
Lord, I am going to read one judgment.
Problem in India.
Your lordship, sir.
See, the standards which were there in the 50s are not the standards there.
Correct. I respectfully, my lord, fully respectfully agree. And I'm going to read one, my lord, judgment while answering the question of judicial review.
Said that the standards of 1950s is narrow-mindedness.
It's
That is
not.
not.
No, no. And this is not open-mindedness.
Narrow-mindedness cannot be the criticism for what was in the.
No, no, my lord. Absolutely right. Absolutely right. What is happening today is not open-mindedness.
Criticism now is that it is narrow-mindedness, myopic, old-fashioned, etc. This is the problem of Indian society today.
Correct, my lord.
It's
And
a struggle of an evolving society.
Yes, of course.
no,
we are
that
evolving.
is transformative constitutionalism, which I have not been able to understand what it means.
So said,
But I have been listening this, my lord, since last few years, transformative constitutionalism. But with my limited understanding, I could not understand.
no, we are not on transformative constitutionalism. That is a good thing for the constitution. We are on the fact that you said public morality. Public morality is also not static.
Correct,
That is what I tried to say.
correct, correct.
Yes.
2 o'clock.
Right.
Thank you.
Now I am on the constitutional morality. Because that is one of the very, very important question which is framed, because that is now started being used as a tool for judicial review. So whether jurisprudentially that is permissible or not. Lord, 49, no, I'll not read, Lord, but this has come from Dicey, and every judgment, my Lord, refers to, but Dicey says that these are constitutional conventions. That is how, my Lord, the origin of the concept started, my Lord. Thereafter, my Lord, history of Greece, I'll, my Lord, leave. Please come to page 50. This concept has been understood correctly by our court also, the way it was floated as a political theory of good governance, not as a tool for judicial review. And that, my Lord, is first judgment is B.R. Kapoor. Lord, please only have a look at the bold part at page 51. I'll not repeat other judgments, my Lord, but one judgment is enough, my Lord. But the constitutional limits bind both the federal and the state organs of the government, which limits are enforceable as a matter of law. Many important rules of constitutional behavior, which are observed by the Prime Minister and ministers, members of legislature, judges, and civil servants, are contained neither in acts nor in judicial decisions, but such rules have been nomenclatured by the constitutional writers to be the rules of the positive morality of the Constitution. And sometimes the authors provide the name to be unwritten maxims of the Constitution. Rules of constitutional behavior, which are considered to be binding by and upon those who operate the Constitution, but which are not enforced by the law courts nor by the presiding officers in the House of Parliament, etc., my lord. Similar, my lord, is, my lord, in the case of state of NGT government and city of Delhi versus Union of India, correctly understood. Not everything, my lord, now thereafter, all judgments refer to Dr. Ambedkar's speech on 4th of November to trace constitutional morality as a part of Constitution of India, which it is. I'm not disputing. The only dispute is whether it is a test for either examining validity of a statute or examination of validity of any executive action. Now, this I may be permitted to read because this is, my lord, thereafter wrongly construed. As to accusation that the draft constitution, your lordships get, my lord? My lord, the Chief Justice. Yes. My lord, this is 4th November 48, Dr. Ambedkar, as the accusation that the draft constitution has produced a good part of provisions of the Government of India Act, I make no apologies. There is nothing to be ashamed of it in borrowing. It involves no plagiarism. Nobody holds any patent right in the fundamental ideas of constitution. What I'm sorry about is that the provisions taken from the Government of India Act relate mostly to details of administration. I agree that administrative details should have no place in the Constitution. I wish very much that the drafting committee could see its way to avoid their inclusion in the Constitution. But this is to be said on the necessity which justifies their inclusion, then Grote, my lord, which is subsequently also quoted by judgments. Then I skip, my lord, that quotation. By constitutional morality, Grote meant a paramount relevance for the forms of the Constitution. I'm sorry, reverence to the forms of the Constitution, enforcing obedience to authority acting under and within these forms, yet combined with the habit of open speech, of action subject only to define legal control and unrestrained censure of those very authorities as to all their public acts, combined too with a perfect confidence in the bosom of every citizen amidst the bitterness of party contest that the forms of the Constitution will not be lost. But at the end, the bold part, it follows that it is only where people are saturated with the constitutional morality, such as the one described by Grote, the historian, that one can take the risk of omitting from the Constitution details of administration and leaving it for the legislature to prescribe them. Thus, the question is, can we presume such a diffusion of constitutional morality? Constitutional morality is not a natural sentiment, but it's a sentiment ultimately. It has to be cultivated. We must realize that our people have yet to learn it. Democracy in India is only a top dressing on an Indian soil which is essentially undemocratic. In these circumstances, it is wiser not to trust the legislature to prescribe forms of administration. This is the justification for incorporating in the constitution. He said, my lord, that why there is a long constitution? Because people are not yet ready for the constitutional morality which Grote was talking about, the reverence to institutions, etc., etc. It was never a doctrine based upon which a legislation can be tested. Now, your lordships may, my lord, come to, my lord, next page. Keshwanand Bharti, my lord, understands or refers to the term constitutional morality. And this would, my lord, be very, very important because large number of, my lord, decisions are coming, my lord, from high courts and this honorable court, where says this provision is violative of constitutional morality. A completely subjective term, my lord, that's the problem. And I'm not, my lord, taking sides, my lord, on this. My lord, something which can be constitutional morality in a particular provision for one honorable judge may perhaps not be so in another judge. My lord, therefore, your lordships would never test either a legislative enactment or an administrative act based on vague concepts, which are, my lord, capable of an elastic interpretation, which is subjective and individualistic. Now, my lord, how constitutional morality is understood in Keshwanand Bharti, page 55. My lord, I have quoted Justice Jagmohan Reddy's view at page 55. This your lordship gets, my lord. This situation could not have been unknown to the framers can be gathered from the speech of Dr. Ambedkar, who said constitutional morality. My lord, I'll skip because I've read that skip. Then kindly see Justice Khanna, only the highlighted part. This would be a flagrant abuse of the power of amendment, and I refuse to believe that public opinion in our country would reach such an abysmal depth and the standard of political and constitutional morality would sink so low that such an amendment would ever be passed. So constitutional morality means the morality which the parliament will examine, the parliament will adopt, the parliament will ultimately revere. Then, my lord, similar, S.P. Gupta, again, my lord, a constitution bench, a convention is a rule of constitutional practice which is neither enacted by parliament as a formal legislation nor enforced by court, yet its violation is considered to be a serious breach of constitutional morality, leading to grave political consequences to those who have indulged in such violations. Well, this is how the term constitutional morality has been understood. Now, your lordships may, my lord, kindly see at page 58, my lord, another judgment, my lord, which is Karnataka is 5 or 7? No, it's a 3 honorable judges, my lord.
Ashwani Upadhyay.
No, my lord, Srimant Balasaheb Patil versus Karnataka Assembly, page 58. My lord, part 3,
173.
chapter disqualification, my lord, schedule 10.
You are referring to para 173.
Yes. 149, my lord, and 150.
173.
Yes, 173. My lord, kindly see only para 150 of that judgment at page 59. Before parting, having ascertained the ambit of the speaker's power, the only regret this bench has is with respect to the conduct and the manner in which all constitutional functionaries have acted in the current scenario. Being a constitutional functionary, the Constitution requires them and their actions to uphold constitutionalism and constitutional morality. Look, this is how the term is understood and used, and that is not a very salutary term. That every constitutional functionary is here, it was chief minister, speaker, leader of opposition, governor. So the court said that everybody has forgotten what the constitutional morality is. Now, my lord, starts emergence of a new trend, which I have pointed out at page 61. Page 61. My lord, I have given, my lord, other judgments also. I'm not repeating, but it takes the term constitutional morality the same way, my lord, as I have referred to other judgments. Now, my lord, the new trend starts, my lord, which is Delhi High Court judgment, Naz Foundation versus Government of NCT of Delhi. My lord, this is, my lord, the judgment of Delhi High Court, which was ultimately, my lord, affirmed in Nautet Johar, my lord, sodomy. Thus, popular morality or public disapproval of certain acts is not a valid justification for restriction of fundamental rights under Article 21. Popular morality, as distinct from a constitutional morality derived from constitutional values, is based on shifting and subjecting notions of right and wrong. If there is any type of morality that can pass the test of compelling state interest, it must be constitutional morality and not public morality. Then, my lord, kindly see the bold part at para 86 of the judgment. In our scheme of things, your lordship gets, in our scheme of things, constitutional morality must outweigh the argument of public morality, even if it be the majoritarian view. Lord, in case of a country governed by democratic principles, the view always which is majoritarian which will prevail, my lord. When it's question of, my lord, testing a law, it is always the majority which passes the law. How can, my lord, you define morality based on this? Thereafter, my lord, subsequently there is a improvement in the.
Majority of a law being passed by majority doesn't mean it is the majoritarian view. There is a distinction between a majoritarian view
I'll not, my lord, go much into it.
majority.
Yes, because that's not the question raised. Now, please see, my lord. It is submitted para 177. Said judgment was initially set aside by this honorable court. However, thereafter, followed by this honorable court judgment in Nautaj Singh Johar and Joseph Shine and Government of India Act, each of which constitutional morality given expanded doctrinal scope. My lord, please have a look. My lord, this is cited, my lord, in Young Lawyers Association, that is Sabrimala case. Kindly see, my lord, the second view of my Lord Justice Chandrachud. The right guaranteed under Article 25(1) has been made subject to, by the opening words of the article itself, public order, morality, health, and other provisions of Part 3 of the Constitution. All the three words, that is order, morality, and health, are qualified by the word public. Neither public order nor public health will be at peril by allowing entry of women devotees of the age group of so-and-so into Sabrimala temple for offering their prayers. As regards public morality, we must make it absolutely clear that since the Constitution was not showed by any external force upon the people of this country, but was rather adopted and given by the people of this country to themselves, the term public morality has to be appositely understood as being synonymous with constitutional morality. Lord, host of judgments saying that the term morality in 25, 19.2, 19.4 is societal morality. Here, my lord, the first departure that it should be constitutional morality, which is subjective. Further, these founding principles must govern our constitutional notions of morality. Constitutional morality must have a value of permanence, which is not subject to fleeting fancies of every time and age. If the vision which the founders of the Constitution adopted has to survive, constitutional morality must have a content which is firmly rooted in the fundamental postulates of human liberty, etc., etc., my lord. Then, my lord, comes Nautaj Singh Johar. Lord, please come to page 64. Page 131, my lord. This is Nautaj Singh Johar where, my lord, page 64, judgment para 131, only bold part. The court has to be guided by the conception of constitutional morality and not by societal morality. This is where, my lord, now the shift takes place and the constitutional morality takes center stage as a tool for deciding validity of statutes. And constitutional morality not only takes a center stage, my apologies, my lord. My lord, the constitutional morality not only takes a center stage, it now excludes societal morality, cultural ethos, nothing, constitutional morality, as, my lord, individual subjective view would, my lord, dictate. Then we may hasten to add here that in the context of the issue at hand, when a penal provision is challenged, your lordships can skip that, 268.4, the primary objective, well, that also, my your lordships can skip, it is more repetition, but 268.5, bottom, constitutional morality cannot be martyred at the altar of social morality. Please have a look, my lord. Now social morality goes, replaced by a vague term called constitutional morality, which never had the meaning which the courts have started giving. Morality that can be allowed to permeate into the rule of law. The wheel of social morality cannot be used to violate fundamental rights to even a single individual, for the foundation of constitutional morality rests upon the recognition of diversity that pervades the society. Diversity is respected, pluralism is respected. How does, my lord, I'm posing a question to myself, it becomes constitutional morality? It may be a constitutional principle. Then, my lord, next page, my lord, para 606. Constitutional morality will impact upon any law which deprives so-and-so individuals of their entitlement to a full and equal citizenship. After the Constitution came into force, no law can be divorced from constitutional morality. Now, my lord, the laws are being tested based on this vague doctrine which never had any place in our jurisprudence. Society cannot dictate the expression of sexuality between consenting adults. That is a private affair. Constitutional morality will supersede any culture or tradition. Now, this is, my lord, the statement of law by 5 honorable judges, which will be further expanded so far as, my lord, sexuality between two consenting adults is concerned in the context of constitutional morality. Now, your lordships may kindly turn the page, my lords. Lord, at this stage, Lord, two things I would like your lordships, my lord, to to assist. And, my lord, I would request your lordships to allow me to read this fully for two reasons. One of the questions my lords have formed is what is the extent and what can be the judicial review? What is the scope of judicial review? And number two, what is constitutional morality, whether it is societal morality or it is constitutional morality? Lord, in this context, Lord, there is a judgment of Joseph Shine versus Union of India, my lord, which I have referred to at page 66.
Page
66, my lord. Lord, this is a case where, my lord, kindly, my lord, I am little concerned as a citizen, as a student of law, and therefore, my lord, kindly, my lord, read this little carefully. This was an adultery provision in challenge. I have no difficulty. Adultery provision is declared unconstitutional. I am not on the merits of the case. I am on the treatment of the judicial review and the constitutional morality, the questions which have directly arisen before a 9-judge bench. And I request, I urge, and I beseech your lordships to read this and examine whether this can be a statement of law in Indian jurisprudence. Please have a look, my lord. Page 68. Gender, the discursive struggle. Your Lordship gets, my lord? This is, my lord, please bear in mind, this is sexual choice of a woman. That is the subject matter. Our constitution is a repository of rights, a celebration of myriad freedoms and liberties. It envisages the creation of a society where ideas of equality, dignity, and freedom triumph over entrenched prejudices and injustices. The creation of a just, egalitarian society is a process, etc. Then kindly see 143. Throughout history, the law has failed to ask the woman question. Lord, I am unable to assist your lordships. What is woman question? But maybe, my lord, gender question, I can, my lord, with my limited understanding.
Where are
The
you reading?
woman question was one of the greatest.
Throughout, sir, para 140.
143 at page 68. Your lordship gets, my lord, the Chief Justice gets.
Yes, yes.
Throughout history, the law has failed to ask the woman question. Within bracket, the woman question was one of the greatest issues that occupied the middle of the 19th century, namely the social purpose of women. It is used as a tool to inquire into the status of women in law and how they interact with and are affected by it. Some, my lord, Lady Catherine T. So-and-so, Feminist Legal Methods, Harvard Law Review. It has failed to interrogate. My lord, kindly now see, my lord, what this lady in Harvard Law Review says is quoted. I am reading it because it is part of the judgment of this court, which is a law under 141 and it binds 140 crores Indians. So therefore, I am reading it. It is not the common morality of the state at any.
Statement of law quotation was this.
No, I'm sorry, my lord. I stand corrected. After quoting, my lord, this is the statement of law by this court. So directly binding on the court, binding on me as a citizen. It is not the common morality of the state at any time in history, but rather constitutional morality which must guide the law. In any democracy, constitutional morality requires the assurance of certain rights that are indispensable for free, equal, and dignified existence of all members of society. A commitment to constitutional morality requires us to enforce this is what has been done even in Sabarimala. Please read it. Requires us to enforce the constitutional guarantee to equality before law, non-discrimination on account of sex and dignity, all of which are affected by the operation of Section 497. Now, please come to, my lord, next page, para 152 of the judgment. My lord,
This you read is part of the article.
no, it is a finding. It's a statement of law by this honorable court. The highlighted bold part is a statement of law after quoting Catherine Brelet. Now 152. The decisions of the US Supreme Court bearing on the issue of privacy has been analyzed in an incisive article. I'm sorry, my lord, page 69, para 188, where I have quoted the same judgment, para 152.
The decisions.
Of the US Supreme Court.
The decisions, this is the judgment, now judgment starts, judgment of the court. The decisions of the US Supreme Court bearing on the issue of privacy have been analyzed in an incisive article titled For Better or for Worse, Adultery, Crime and Constitution. Martin Siegel, so-and-so, he represents three ways in which adultery implicates the right to privacy. The first is that adultery must be viewed as a constitutionally protected marital choice. Second, that certain adulterous relationships are protected by the freedom of association. And finally, that adultery constitutes an action which is protected by sexual privacy. Therefore, social morality, because it is done in private. Adultery is in private. Justice Kalia says that none of these activities I have seen which is being performed on a stage. I'll come to that. Then, my lord, 154. Sejal points that a decision to commit adultery is a decision relating to marriage and family relationships, and therefore falls within the domain of protected private choices. He observes that the essence of the offense is, in fact, the married status of one of the actors, and mere fact that commission of the act consisted of a mere sexual act or a series of them is legally irrelevant. If the argument that adultery, though unconventional, is an act related to marriage and therefore fundamentally private is accepted, then it deserves equal protection. Siegel cites so and so, and thereafter, my lord, some judgments are cited. Kindly turn the page, my lord, page 70. The mere fact, my lord, your lordship gets. Now, this is the High Lord Court's observation. The mere fact that adultery is considered unconventional in society.
Just a minute, Mr. Because Cecil is, this Cecil, what is his name?
Siegel, my lord, it seems, my lord, I have Martin J. Siegel, my lord, I have come across.
He has been quoted like second Ambedkar, almost.
Yes.
So
Because I have
there
seen,
is
my lord,
no page
Justice
78.
Douglas, Jagdish Frankfurter, Justice my lord, Denning being quoted, but my lord, articles of some, my lord, unknown would be, my lord, very difficult, because that becoming part of the judgment binds us. His views are now part of the judgment, and these views are accepted and followed by your lordships on the ground of constitutional morality. Lord, please come to page 70. He's a practicing lawyer in America, my lord. The mere fact, your lordship gets, my lord, the top.
Yes.
The mere fact that adultery is considered unconventional in society does not justify depriving it of privacy protection. The freedom of making choices also encompasses the freedom of making an unpopular choice. In a married relationship, I can have adulterous relation because that is my private choice. It may be unpopular or unconventional. This was articulated by Justice Blackmun in the dissent in Harvard versus, Bowers versus Hardwick. But there is something more. Hmm? So, my lord, the Honorable Court cites Bowers versus Hardwick. My lord, this was a decision regarding
Viewpoint or subjective viewpoint of some professor, some writer, some author, some whosoever he may be. We do not know. We have no fair idea about his eminence. That his view has been followed, but ultimately the judgment as such is not now under question. The judgment.
the judge. Kindly, no, Lord, I'm saying something. Lord, please have a look at page 71.
Mr. Solicitor, what the Honorable Chief Justice is indicating is these are observations of one of the Honorable Justices, but the ratio on the basis of which Joseph Chine declared
Lord,
adultery
why are we
uncompromised.
shying away from read? My Lord, allow me to read it. Lord, I'm saying with a sense of responsibility.
It's a issue of gender discrimination where the equality in gender has not been respected in the law.
My Lord,
Woman has been deemed to be in the sense of property, not being sui juris in the matter of initiation of prosecution.
my Lord, allow, my Lord, with a sense,
Fundamental issue as we read it.
Lord, with a sense of responsibility,
Yes.
allow me to read it and read it further. My Lord, 497 could have been declared unconstitutional on the ground of Article 14, that it is arbitrary, discriminatory.
13 and 14.
Now,
In fact,
For
it has
enforcement
been
of-
declared so. These are certain observations of one of the honorable justices, as his lordship then
my
was.
Lord, they are not, my Lord, kindly allow me, my Lord, kindly allow me. Why should we not, my lord? I must, my lord, point this out.
You can say that for enforcement of fundamental rights, it need not be on the touchstone of constitutional morality. Constitutional morality is in the realm of constitutional governance. It's not in the
That's
realm.
my submission.
Yes.
If I have something more to say, allow me to finish this. Allow me to finish.
Say that the approach
I'm grateful, but allow me to finish.
may not be palatable to you, but then that is not the subject matter as such here.
It is, my lord, I'll,
Morality under Article 25 and 26.
I'm coming to say constitutional morality only. And my lord, I would wish, my lord, allow me, my lord, let just have some pay, my lord, I'll complete before 4 o'clock. I want 9 honorable judges to read whether this part which binds me is a correct statement of law or not.
Our question is, does it
Yes,
bind you?
Lord, page 71, reflecting, my lord, please allow me, my lord. Reflecting on the relationship, my lord, kindly read. Reflect, my lord, page 7. Lord, there is a request after that. Please allow me to complete and I'll make a prayer, my lord. There is a prayer. Reflecting on the relationship between marital privacy and associational freedom, Siegel remarks the heterogeneity of experience resulting in a variety of, pardon, Lord, page 71, bold part. Somewhere in the middle, the bold part, page 71. Yes, reflecting on the relationship between marital privacy and associational freedom, this is, my lord, considered and followed in Sabrimala. Therefore, I am requesting. Siegel remarks the heterogeneity of experience resulting in a variety of choices necessarily include, the court says, adulterous union which must be protected since it is unrealistic to expect all individuals to conform to society's idea of sexuality. Because, my lord, quoted part I'll skip. Then Catherine McKinnon, my lord, some New York University, implores us, my lord, from Siegel's article, my lord, that's, my lord, the Catherine McKinnon implores us to look more critically at the reality of this family sphere termed personal and view the family as a crucible of women's unequal status and subordinate treatment sexually, physically, economically, and civilly. Now, 182. Now, this is the finding of the court. Implicit in seeking to privilege the fidelity of women in a marriage, now court decides on fidelity, is the assumption that a woman contracts away her sexual agency when entering into the marriage, that a woman by marriage consents in advance to sexual relations with her husband or to refrain from sexual relations outside marriage without the permission of her husband is offensive to liberty and dignity. This is followed in Sabrimala. The liberty and dignity of women, that when a woman gets married, or for that man, a man gets married, we barter or mortgage our choice of having sexual relation with someone else, except husband or the wife. That's the finding. That's the law declared by this court. Further, my lord. Now, 194, and there is something very, very serious, my lord, which I have. I have a very serious objection. Nivedita Menon is quoted twice. I don't wish to, my lord, JNU professor, my lord, known for his views that Indian state is illegally occupying 2 states, etc., etc. I'm not going into it. But now it has the status of being a part of Supreme Court judgment, which is a court of record.
If these Harvard professors who have nothing to do with Indian society have occupied so much space, what is wrong with an Indian professor?
Lordships are right, my lord. I respectfully bow down. I respectfully bow down.
So even without all this, the validity of the section could have been.
I'm not on validity. I'm not on validity. It remains invalid. I'm not on validity. But this view is the view which is foundation of Sabrimala. That dignity is dignity based on gender. Please have a look. 218. This is again the finding of the court. And I'll read from Sabrimala. 218. This court has recognized sexual privacy as a natural right protected under the Constitution. To shackle the sexual freedom of a woman and allow criminalization of consensual relationship is denial of this right. Section 497 denudes a married woman of her agency and identity employing the force of law to preserve a patriarchal conception. Lord, fidelity, is it a patriarchal conception? It applies to me also. It applies to man also. It's not, my lord, applicable to fidelity is not expected only from women. And patriarchal conception of marriage.
Because it was a one-sided offense, the provision was on the face of it unconstitutional.
It could have been Article 14, I concede.
4 lines could be struck down.
It should have been. It should have been.
Offending
Then
provision
further, then
only
further.
against women.
Infidelity was born on the day that natural flows of sexual desire were bound into the legal and formal permanence of marriage. In the process of ensuring male control over progeny and property, women were chained with the fetters of fidelity. Lord, fidelity expected out of the marriage is termed by this honorable court, and which is a court of record, as a shackles of sexuality. I am arguing, my lord, societal morality versus constitutional morality. Is it, my lord, I am putting a question to myself, a constitutional, societal morality? This is not, my lord, the jurisprudence of our country. It's not jurisprudence of my country. And I don't think there would be any dispute on that. Then further, constitutional protections and freedoms permeates every aspect of citizens' life. The delineation of private or public spheres become irrelevant as far as the enforcement of constitutional right is concerned. Therefore, even intimate personal sphere of marital relations is not exempt from constitutional scrutiny. The enforcement of forced female fidelity by curtailing sexual autonomy is an affront to the fundamental right to dignity and equality. This is the right which is the foundation of Sabrimala. Right to dignity and equality. Now, Lord, there are
Institution of marriage in India is based on fidelity of not only by the wife, but the husband also.
husband, yes. And you say it's patriarchal, it applies to man equally. You take that oath, whether it's Christian marriage, whether it's nikah, whether it's saptapadi, you take oath to remain faithful to each other. When I marry, I do not mortgage my choice of having sexual relation with someone else. The society, the norms, the cultural ethos, Lord, accepts that fidelity from me. Otherwise, I don't marry and do whatever I do.
Even if you ignore the societal or cultural norms, let us not bring these principles while testing that provision. The point is that how can there be that something an offense for woman and no offense for the man? On that ground, particularly when it's a mutual.
That is wrong, my lord. I'm not, my lord, saying that you please revisit that. But this is considered to be a part of dignity of a woman. And dignity of the woman is the ground for Sabrimala. Now, my lord, I have three problems with this judgment, and I am requesting your lordship. There is
In other words, you're saying this is the foundation.
yes, it is foundation.
Just para 189 also you are saying.
Yes, ma'am. 189. The judgment in Joseph Shine proceeds on a premise which is not only against the societal morality, but even against constitutional morality. If Indian constitution is being considered, the judgment of Joseph Shine in para 152 and 154 not only cites, fully relies upon and makes a part of the judgment one professor come lawyer Martin Siegel, which binds the entire country, etc. But Lord, there are two other problems. But Lord,
Now, if you go by this, the presumption of paternity also will go. So
it
obviously,
has to. It has to.
it'll go.
Because a woman can say or a man can say that I am not supposed to, it's a private, intimate affair.
It's not may presume, but it's not shall presume. It's a conclusive proof unless, no, it is debatable even otherwise. Now it will go.
It will become need not be presumed.
Okay. Yes.
Lord, I had,
Institution of marriage and monogamy is precisely for the reason that there should not be multiple partners.
may not be. That's the societal morality, my lord. We cannot divorce our jurisprudence from that societal morality.
The entire judgment, there is no Indian philosopher quoted.
Except Nivedita Menon.
So-called Indian philosopher. All.
Now, my lord, the problem is the court quotes Bowers versus Hardwick. I'm not going into the details. The court quotes minority judgment in Lord Blackman in Bowers versus.
Partly blame can go to the law clerks also. They do lot of.
My lord, I have my limitations, my lord. I will not say that, my lord, because majority view takes the view which I am canvassing, which, my lord, I would say within the limitations which I have, has escaped the attention of the bench. The majority view has escaped the attention of the bench, and therefore minority view is quoted without quoting the majority view. Now, my lord, comes this very view which the learned judge relies upon. This Bowers versus Hardwick minority view is quoted. Lord, was tested again in Lawrence case, where there is a beautiful two minority opinions, 5 versus 4 of the US Supreme Court. I have not cited any US judgment.
There was one very interesting, if I recollect, by John Roberts, Justice.
Chief Justice Roberts, my lord, please come to that directly. I have cited, my lord, page 76. But before that, can I show one page of Scalia, Justice Antonian Scalia? It's 5 versus 4. The first case was sodomy, and Justice Scalia and others dissented. And please see, my lord, what Justice Scalia says at page 75. Then immediately I am obliged, my lord, to my lord, the Chief Justice. Second para. Next, the court makes the claim. My lord, here court would mean the majority. It was a thin majority of 5 versus 4.
But Mr. Solicitor, when you are speaking of English and American courts, morality vis-a-vis sexual acts like sodomy, etc., we should also bear in mind that the idea of sodomy or Gomorrah is a Victorian concept of immorality. In India, the traditional moral thoughts were not at all anti-libertarian in choice.
I would not, my lord, very respectfully respond to that because my views are different, but that's not relevant.
It's not our view or your view. It's
No. Whether Indian view. No, whether Indian view is different or not.
If you see in Justice Nariman's judgment, saying that these are Victorian morals. They were actually imported into the Indian liberal society.
My lord, that is, my lord, view of Justice Nariman, my lord, with
Yes.
which I respectfully disagree,
Yes.
because that has
Because he
always
was-
been immoral
he was
even in
from
Indian context.
India.
But let's not go into it.
So if
I'm,
if you logically deduce from this, how will one file a petition for divorce on the ground of adultery? Because on the touchstone of the constitution,
but the,
if you say that it's part of liberty, now can anyone?
it's not a cruelty, because I was exercising my choice. It was a question of my dignity, my bodily autonomy.
My learned brother is saying
Not to-
divorce on the ground of adultery
Adultery.
can never lie.
Can never lie. Exactly, that's what I am responding. That a person would say that there is no question of adultery because that's my dignity.
See, still notwithstanding adultery, I would like to continue with the relationship, with the husband-wife relationship.
It depends with me that this is my constitutionally
Right,
protected right.
Protected right, so it cannot be a ground on which you grant divorce.
Whatever the provision will bring in, it can't go against the constitution.
Cannot. Now, my lord, I am not now on sodomy being good, bad, moral, immoral. I am on the judicial review. And that is what Justice Kalia and Chief Justice Roberts, my lord, very beautifully explained. My lord, it was mere coincidence that this was a case of Sodom. Please see, my lord, page 75, unnumbered para 2. Next, the court makes the claim. Court means, my lord, majority, 5. Kaskalia is 4. The claim, again unsupported by any citations, that laws prohibiting sodomy do not seem to have been enforced against consenting adults acting in private. The key qualifier here is acting in private. Since the court admits that sodomy laws were enforced against consenting adults, although the court contends that prosecutions were infrequent.
From where you started, Mr.
But I'm sorry, page 75, second para, unnumbered paragraph. Next, the court.
75.
Yes. Next, the court means, my lord, the majority, 5 judges versus 4. Next, the court makes the claim, again unsupported by any citations, that laws prohibiting sodomy do not seem to have been enforced against consenting adults acting in private. The key qualifier here is acting in private, since the court admits that sodomy laws were enforced against consenting adults, so and so. I do not know what acting in private means. Surely, consensual sodomy, like heterosexual intercourse, is rarely performed on stage. Then, realizing the fact that the court instead says, that is the majority, we think that our laws and traditions in the past half century are of most relevance here. These references show an emerging awareness that liberty gives substantial protection to adult persons in deciding how to conduct their private lives in matters pertaining to sex. Then skip that. Next, the court's discussion of these foreign views, ignoring, of course, the many countries that have retained criminal prohibition on sodomy, is therefore meaningless dicta, dangerous dicta. However, since this court should not impose foreign moods, fads, or fashions on Americans, I emphatically rely upon it. My lord, the converse is also true. Today's opinion is now, my lord, why should the court not go into it in a judicial review discussion? Today's opinion is the product of a court which is the product of law profession culture that has largely signed on the so-called homosexual agenda, by which I mean the agenda promoted by some homosexual activists directed at eliminating the moral opprobrium that has traditionally attached to homosexual conduct. Please note, I noted in an earlier opinion the fact that American Association of Law Schools, to which any reputable law school must seek to belong, excludes membership any school that refuses to ban from its job interview facilities a law firm, no matter how small, that does not wish to hire a prospective partner. The court says this emanates from eminent American law schools. This idea, there is a narrative building which starts. it is clear from this that the court has taken sides in the culture war, departing from its role of assuring as neutral observer that democratic rules of engagement are observed. Lord, last three lines. So imbued is the court with the law profession's anti-homosexual culture that it is seemingly unaware that attitudes of that culture are not obviously mainstream, that in most states, what the court calls discrimination against those who engage in so and so is perfectly legal. Then, my lord, read part. But persuading one, Lord, court said that remedy is you persuade your fellow human beings to accept your view, like, my lord, in religion, that you persuade them that permit entry of women if there is some logic, etc. Don't do it by a judicial fiat. My lord, now, as my lord, the Chief Justice, my lord, I'm kindly said, Chief Justice John Roberts' minority view. We hear the learned Chief Justice is in minority, but my lord, these words will haunt all of us, my lord, after reading it. How the learned Chief Justice, my lord, perceives this kind of a situation being examined in a court on morality grounds, forgetting the morality at all. Please see, my lord. Today, however, the court takes the court means majority, extraordinary step of ordering every state to license the recognize same-sex marriage. Many people will rejoice at this decision, and I begrudge none for their celebration. But for those who believe in a government of laws, not of men, the majority's approach is deeply disheartening. Supporters of so and so have achieved considerable success persuading their fellow citizens through the democratic process to adopt their view that ends today. 5 lawyers, that is the 5 honorable judges and majority. 5 lawyers have closed the debate and enacted their own wisdom of marriage as vision of marriage as a matter of constitutional law. The majority's decision is an act of will, not legal judgment. The right it announces has no basis in the Constitution or this court's precedent. The majority disclaims judicial caution and omits even a pretense of humility, openly relying on its desire to remake society according to its own new insight into the nature of injustice. Ante at so and so. As a result, the court invalidates the marriage laws of more than half the states and orders the transformation of a social institution that has formed the basics of human society for millennia, for the Kalahari Bushmen and the Hans Chinese, the aboriginals, to the modern, the Carthaginians and the Aces. Now, Aztecs, my lord. Now the court Chief Justice says, just who do we think we are? My lord, these words, my lord, would be haunting. Who do we think? Are we social reformers as lawyers? And he says, my lord, his lordship says in a judicial review, that who do we think we are? 5 lawyers, and please see further. It can be tempting for judges to confuse our own preferences with the requirements of law. But as this court has been reminded throughout our history, the Constitution is made for people of fundamentally different views. Then accordingly, courts are not concerned with the wisdom of policy, legislation, etc. Please see the red part. And it answers that question based not on neutral principles of constitutional law, but its own understanding of what freedom is and must become. I have no choice but to dissent. See the, my lord, vigor of the dissent. Understand well what this dissent is about. It is not about whether, in my judgment, the institution of marriage should be changed to include same-sex couples. It is instead about whether, in a democratic republic, that decision should rest with the people acting through their elected representatives or with 5 lawyers who happen to hold commissions authorizing them to resolve legal disputes according to law. The Constitution leaves no doubt about the answer, allowing unelected federal judges to select which unenumerated rights rank as fundamental and to strike down state laws on the basis of that determination raises obvious concerns about the judicial role. Our precedents have accordingly insisted that judges exercise the utmost care in identifying implied fundamental rights, this right to dignity based on sexuality, implied fundamental rights, lest the liberty protected by the due process clause be subtly transformed into the policy preferences of the members of this court. Yes, my lord, his lordship has not minced words. Further, my lord, thereafter, in this also, my lord, this was a marriage case. Justice Kalia pens a dissent, and please see the bold part on the foot of this page 77. Take for a, my lord, I'll read the full. Judges are selected
Just read through highlighted lines of John.
over and
Roberts also.
yes, I'm sorry. Over and over, the majority exalts the role of judiciary in delivering social change. Those who founded our country would not recognize the majority's conception of judicial role. My lord, if these judgments, Nautet Johar, Joseph Shine, etc., were to be read by Dr. Ambedkar or Kanayalal Munshi or Aladi Krishna Swami Iyer, I do not know, my lord, whether they would be surprised, shocked, or they would say that yes, this is what we wanted. I believe they did not want this to happen. But, my lord, now, my lord, Justice Kalia, second para. Judges are selected precisely for their skill as lawyers. Whether they reflect the policy views of a particular constituency is not and should not be relevant. Constituency means a particular point of view. Not surprisingly, then, federal judiciary is hardly a cross section of America. Take, for example, this court, which consists of only 9 men and women, all of them successful lawyers who studied at Harvard or Yale Law School. 4 of the 9 are natives of New York City. 8 of them grew up in East and West Coast states. Only 1 hails from the vast expanse in between. Not a single Southwesterner, or even to tell the truth, a genuine Westerner. California does not count. Not a single evangelical Christian, a group that comprises about 1/4 of America, or even a Protestant of any denomination. The strikingly unrepresentative character of the body voting on today's social upheaval would be irrelevant if they were functioning as judges, answering the legal question whether the American people had ever ratified a constitutional provision that was understood to proscribe the traditional definition of marriage. But of course, the justices in today's majority are not voting on that basis. They say they are not. And to allow the policy question of same-sex marriage to be considered and resolved by a select, partisan, highly unrepresentative panel of 9 is to violate a principle even more fundamental than no taxation without representation, that is, no social transformation without representation. My lord, I am respectfully urging, my lord, your lordships is a court of plenary jurisdiction.
Whatever may be the outcome of these proceedings, that we do not know. But these 9 judges will never be criticized for this. For non-representation. This criticism at least will not be invited by us.
Thanks to Chief Justice.
Thanks to the Chief Justice.
No, my lord, there are no.
System of
Whatever may be our outcome, outcome can be wrong also.
No, anything, my lord.
Nobody is perfect.
My lord, there are only 3 reasons, and I'll switch over to the next point. A, your lordships are a court of plenary jurisdiction.
I didn't realize what you said.
Yes, yes.
But hinting about the composition of this bench, you can't say no
It is
representation.
representative, my lord, and none of them, my lord, have come from, my lord, Harvard and Yale, and this, my lord, reflects, my lord, those who have risen from the ranks and they have played on the streets. So we know, my lord, what the social morality is. My lord, Lord, your lordships have the plenary power. Your lordships are a court of record. Court of record not only enables, but makes it a duty. If this is the statement of constitutional law, it's to be dealt with properly. But based on this fundamental principle, the dignity of a woman, the implied fundamental right, is the foundational basis of Sabrimala. Therefore, your lordships will have to necessarily pronounce upon the validity, correctness, or, my lord, otherwise, of these observations. Now, my lord, I'll come to next, my lord, subject. My lord, page 82. I'm not taking your lordship, my lord. Last part, I'm not even reading. I'm just giving oral propositions because I know it need not be read. Your lordships are fully aware. Blanket reliance on international judgment is impermissible. I have given the judgments. My lord, it's at page 82. I have given all the judgments on the point. My lord, please, my lord, as a combination, as a, my lord, sitting as 9-judge combination, please, my lord, hold this, that blanket reliance, my lord, is impermissible. And I'll read only one judgment in Keshwanand Bharti. My lord, please see page 83, para 1107.
Mr. Solicitor, you have already qualified by using the blanket. There is no controversy. There can't be any blanket.
Yes, yes.
It's only that in the backdrop of factual position
No,
that we follow
only thing,
certain principles. Sometimes we don't find our own president available, then we,
Such-
as a guideline, we take it.
but my lord, for the purpose of, my lord, some issues, it's always preferable, my lord, to avoid. My lord, then page 91.
Persuasive value.
Page 91. Judicial review on, my lord, unfortunately, the court was not assisted with the other two judgments, Lawrence and Objerfel, my lord, which I read. The court should have been assisted, my lord. Courts, therefore, it seems that the court's attention has missed, my lord, because of our inability to assist correctly.
Our approach is better. We write our own separate judgment, but we don't criticize the other judgments.
That's true. That's correct.
It's
That's a
we are
healthy thing.
More mature and more.
That's a healthy thing. Lord, this is, I found, happens only in America.
This has no relevance.
Your lordships are right. Absolutely right. My lord, this is on, my lord, I'll not say anything right now, but I have written something on that. This is only in America that there is a response to the majority by the minority. And one more thing, there is a rejoinder by the majority to that minority.
But it is on the topic. I've also done that. I've also given a rejoinder in a differing view, but on the merits, not on the comments of the mind thought of a person. This is a personal comment. We are more mature as a system.
No, absolutely right. Our system is more matured and it maintains the dignity of the highest court of the country. It should not be seen that the judges are fighting inter se and saying anything. But this is the position. In America, this is the position. But
On an intellectual level, see, that is why,
intellectual.
that is why a dissent is always longer than the main judgment.
dissent is, my lord,
To,
call for the brooding spirit of the future generation.
so,
The viewpoint.
But
yes,
there,
you have to
Mr.
counter
Solicitor,
that.
you are quoting an American Chief Justice.
Yes, yes, my lord. My lord, I have never quoted any American judgment,
No,
but
I'm saying
this,
when you use that word, the brooding spirit of a future
Justice Hughes.
my lord,
society.
I think Justice,
Justice Hughes.
Huge is
yeah, huge.
Vance-
Justice huge.
Vance Hughes.
quoted by Justice Khanna in his dissent. But that again is an American Chief Justice.
It is. But whenever we see, my lord, the law,
But Mr.
whenever we see law of dissent, it starts with this, my lord, academic law of dissent. They starts with this. And in some of the countries, my lord,
We should always look for the best from everywhere and
Lord-
not be a slave of anywhere.
I would, my lord, put it differently.
East or the West?
Lord, we should expect light from every quarter of the world, provided we are in dark. Let us not reverentially follow something coming from the West and, my lord, introduce it selectively in our jurisprudence.
Now you are commending Chief Justice Roberts to us now.
My lord, now, my lord, page 91, your lordship is right. My lord, judicial review on vague notions, my lord, not permitted. And my lord, my lord, page 96, my lord, I have given one more nuanced my lord, interpretation. Because, my lord, we as our culture is, we generally, my lord, attempt to be polite and my lord, express ourselves in the most humble way. My lord, these are the views which are no holds barred. My lord, there is no mincing of words. That who do we think we are? Are we here to reform the societies? We are 9 of us studied in Harvard and Yale. We don't have the representation, etc., etc. But therefore, it was really, my lord, something which I thought must place before your lordship.
But there is nothing personal attack. That's also beautiful reasoning their own way.
Yes, yes, my lord.
We may not agree, we may agree that or
They,
disagree, but that's that.
they have
that's
not
the
said
way
that you are
it is.
fools or something, you are not understood or your understanding is lacking. They have said that this is not the way in which you as judges deal.
It is, Mr. Solicitor, the First Amendment culture.
Yes.
First Amendment,
First,
unhindered.
First Amendment without reasonable restrictions.
First Amendment culture.
But without reasonable restrictions. Well, their First Amendment culture, freedom of expression, includes right to burn national flag as a form of expression of anger against the government. In our country, it's a criminal offense. Therefore, in right citing,
Article 19(2), like we have here, is not there.
not that, it's absolute.
Content.
No, my lord, it's absolute terms. There are no reasonable restrictions, none of the provisions. And that's what, my lord, Justice Douglas said while comparing it with India, that we don't have reasonable restrictions like India. Lord, now please come to page 96. The classic, my lord, what I have said is, my lord, I'll just paraphrase and, my lord, leave it at that.
Page
Page 96.
96 is only on question number 5.
Yeah, yes. Page 9, my lord, it's on my lord, judicial review. Judicial review only. But I have come out of, my lord, just as a citizen, as a
His view also have a bearing on this.
yes.
Actually, what he actually meant is only this. That's what.
Yes, my lord, that religion.
Forget about the other part. Actually, what he meant was that we should be very careful in not having a personal views into you. Don't inject it.
Exactly. My lord, that's, I'm grateful. That was the case.
This
That
is also what
forget
he-
homosexuality, forget same-sex marriage, the judicial review.
You just find out what is available under the constitution, do it accordingly. Don't go beyond.
Don't, what the constitution should have been, what the society should have been,
Social
is
reform.
not the function.
Yes.
But we should credit you for taking so long on that question that it's also showing us the mirror.
No, my lord, I was showing myself the mirror that we missed to point this out, my lord, to the honorable bench.
So that from that we can also look at ourselves.
My lord, nobody, my lord, that's not the purpose.
Point taken.
That that is, my lord, something very, very serious. Your lordship taking that point is a serious
That was
thing.
in a lighter way.
Obviously, my lord, I know your lordship would never.
Yes.
Lord, the proposition which I have made is, Lord, once a religious belief or faith question comes, and somebody comes and says, either as a petitioner or as a respondent, that this is my faith and this is my belief, my religion permits, and this faith and belief is widely practiced, then it is a rebuttable presumption. I don't have to prove that this is my faith and belief. I don't have to prove that this is a part of 25. It will be for those who are opposing it to prove that no, it is either against public interest, public order, or against morality, or against health, or my lord, part 3 of the Constitution. Lord, that is how, my lord, I have put it. And Lord, then page 99. My lord, 98, my lord, if your lordship sees, my lord, I have earmarked the structured review. My lord, this is the suggestion that this
96. You want to refer
page
to
98, page 98. Para 252.
Linguistic gymnastics.
My lord, structured review. My lord, your lordships can read A, B, and C. I'm not reading it right now because of I don't wish to waste time.
Next
But
point
D, I'm
also,
tempted.
next point also, proper remedy of a civil suit. You had in the beginning itself pointed out.
I did point out, my lord, that ultimately, my lord, these are all questions of fact. Whether faith is there or not, what is the pervasiveness of that faith and belief, whether it is a part of religious faith or not. There also, my lord, I may have to, my lord, examine expert witnesses and the court would have the assistance. So 25, 26, Article 25 and Article 26 are the questions which may perhaps not be permitted to be, possible to be decided on affidavits. Somebody says this is a belief long held, and somebody said no, this is not a belief at all, or it's not a part of our religion at all. How would your lordships decide as a court of judicial review, as a court of first instance? That's for, my lord, I have said that remedy, if at all, is with a limited my lord, jurisdiction, judicial review, but will be the civil suit. My lord, then I have given, my lord, some judgments. Then, my lord, I have given the critique of essential religious practices doctrine. My lord, on that, all of us are ad idem, as I understand as of now.
That is extent of judicial review.
Page 103, my lords. My lord, it is a question. Yes, my lord, question is,
Essential religious practice.
yes, my lord, question number 5.
Paragraph 265 of your written submissions.
Yes,
Page 103.
yes. My lord, it's question number 5. No, not extent of this. My lord, there is a question framed by your lordship, my lord, about essential religious practice. No, I'm sorry. It is extent of judicial review question. That's the test, my lord. Whether that can be the test or not.
You're having this test under Article 26 or under Article 25.
My lord, my view is same, subject to what my other learned friends wants to say. And I didn't want to, my lord, repeat because I attempted yesterday. My lord, both rights are fundamental rights. Article 26B is a right which is not an island, but between the two, being a denominational right, would have, my lord, a precedence, provided that if there is some provision of law which requires it to be curtailed or to be regulated or restricted, then it would be 25(2). And my concern, my lord, also I have shared, my lord, if we say 26(2), 26B is unhindered, my lord, then there can be an argument that even people from scheduled caste, forget 17, can also be prevented. Worry is, my lord, and a larger worry, this is my worry. My lord, if that is the way in which it is interpreted as standalone provision without being, my lord, I'm aware, my lord, some states are taking away control of, my lord, some religious institutions, and there is a serious issue going on. But if this right is conferred upon the denomination, Lord, one denomination amongst, say, Hindus or Muslims will prevent another denomination of the same religion. It will prevent another denomination of the same religion. Lord, we may not create a situation where there is disharmony internally amongst the religions. So, Lord, it would be the rare circumstance where you will interpret 26B subject to 25B, but it would never be an isolated island provision.
So we are not clear the applicability of the essential
No, yes.
test with regard
It
to.
is not possible.
In the context of Sabrimala, how does it arise?
But my lord, it says, the Sabrimala says that it is not a denomination at all.
Yes.
It is, in any case, it's not an essential religious practice. But my question is, first, whether it is necessary for me to prove that the religion, religious practice, or affairs regarding religion is essential. Once I prove that these are religious practices and it does not fall foul of public order, morality, and health, where the essential doctrine comes. There is no, my lord, the textual reading of 25 or 26.
Able to follow.
Yes.
What is the relevance of that doctrine on the issue in Sabrimala?
Lord, first of all, the question is not framed on Sabrimala. Question is,
But why this
judici-
question is raised now then?
yes,
Can
yes,
it
yes.
be in a vacuum?
I'll just, my lord, tell you, there is no vacuum. My lord, Serur Mutt, which is the highest strength so far, 7 honorable judges, does not say that essentiality is to be proved. Correct? Serur Mutt doesn't say that. It was Dargah committee, 5 judge, which misinterprets Serur Mutt and says that for being protected as a religious practice, you have to show that it is not only religious, it is essential to the religion.
Is that from the religious practice or religious practices, it has traveled to essential religious practices by virtue of use of this expression.
I am great.
essential
My lord, I
in a
could not.
particular judgment.
Yes.
And that judgment has been followed in Sabrimala.
Yes.
Therefore, it is required to be determined
I am grateful.
whether, yes, that is the background there.
That is, my lord, the relevance of this practice. Otherwise, my lord, what?
It's not an essential religious practice.
Exclusion of women is not essential.
We want to know little context to it regarding this
My lord,
question.
questions framed has no context.
That requires
The characteristics of the deity was argued.
Yes, my lord. Otherwise, my lord, this results into ad hoc results.
Differently, to say differently, contention is that what is required to be proved is only that there is a religious practice. Once that religious practice is there, and once that religious practice does not fall within the 3 exceptions referred to in 25 and again in 26, then that itself ensures protection of 25 and
Additional
26.
condition of
Held
it
the
being
case.
essential is not. My lord, otherwise, what
The
happens?
additional onus of proving that practice as an essential religious practice is neither here nor there. It is neither in the constitution nor it was held by the 7 judge bench, which was until that day.
Nor contemplated by the constitutional framework.
Your argument that
Otherwise, my lord, what the difficulty is? My lord, say religions like Hinduism. We have Hinduism, Islam, Christianity. My lord, other 2 religions have one creator, one originator, one holy book from which you can show that this is what is stated and therefore it is essential. Hinduism, as I have said, is not only having plurality, it is internal plurality also. And there is no one originator, no one creator, one God, one religious scripture. It becomes impossible at times to show that this is essential. So it creates, my lord, an arbitrary situation, and therefore, my lord, also this essential religious practice doctrine, which is inserted, according to me, wrongly, my lord, in the judgment, which is contrary to Shirur Mutt, is, my lord, a wrong interpretation. Apart from textually, it doesn't come out either from 25 or 26. That is my, my lord, respectful submission.
Religious practice, it is sufficient according to.
Yes, 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 my lord.
That is the
The last submission is, my lord, that in my lord, every religion, there are certain attributes attributable to the deity. And you have to go by those attributes. The secular courts are not supposed to sit in appeal over the validity, legality, propriety, or rationality of attributes of the deity. Like, my lord, in case of Ayyappan Swami, which is Naistik Brahmachari. And therefore, there are certain rules which have been followed. Lord, it would not be possible or permissible to examine the attributes of the deity. And every deity, my lord, has a particular attribute across religions. Number 3, comparative intra-fundamental right conflict. And this is, my lord, my last submission. Lord, whenever we talk about one particular fundamental rights, it affects more than one individual. Lord, my right to speak affects my learned senior friend's right not to be offended. I should not speak anything which is derogatory or defamatory to him. So it is his corresponding right. So right of entry into a temple will have to be tested in the context of right of devotees who feel that particular class of persons should not be permitted to enter. That is never examined at all, Manoj. You can say that one or few individuals wants to go, but has anyone examined the corresponding fundamental right under Article 25? My right under Article 25 and 26 is that if my religious tenets, if my religious belief or faith prohibits a particular thing to be done, it will not be done. So even my right as a follower
Subject to reasonable restriction, that aspect has not been considered.
and proportionality,
What?
that has not been considered. Manoj.
So would you be,
Even before that, sorry.
would you be assisting us on, also on the basic facets of Lord Ayyappa?
I'm sorry.
Will you be also assisting on the background that what was already integral part of the rituals about entering of Lord?
No, my lord, yesterday it was clear that we are not addressing the court on the merits of the matter. My lord, I said yesterday that Sabarimala judgment is wrong, which I will, my lord, demonstrate irrespective of what view your lordship takes on 25, 26 being read together, being read separately, irrespective of that. I am in favor of review. I am saying it is a wrong judgment. But, my lord, it was decided that the reference says that it is referred to 9 honorable judges to decide the judicial policy how to deal with religious freedoms. And therefore, my lord, as we all of us understood that on merits, the Sabarimala judgment and its correctness or otherwise is not to be gone into.
See, what follows from what you have said just now, the writ petitioners, original writ petitioners, if we have understood correctly, are not the devotees.
No, it's some.
No devotee has approached this court challenging this. Then who is the writ petitioner who is assailing this?
Lord, there are more than only a minute, only a minute.
Who is the original writ petitioner?
Original writ petitioner is one in Young Lawyers Association.
They are not devotees.
Lord, but
Devotees who are on this side, I'm representing one
No,
of them.
1 minute, let us be clear. Can any devotee of Lord Ayyappa file a writ petition challenging it?
it is not, my lord. It is not.
If
Lord-
non-devotee, a person who is not concerned with the temple challenges it, can this court entertain the writ petition?
Please see question 7. Question 7.
Then that should be addressed first.
Yes, my lord. Kindly come to, my lord. I'm not reading it. I'll not reading, my lords. But please have a look at, my lord. Don't, my lord, feel that I'm reading. Come to page 120.
That the 5 judge bench has taken the view, following the general principles of PIL, that if there is an element of public interest in an issue, the court can examine. That is what Justice Nariman, while upholding the maintainability of the PIL, and the other honorable judges have taken the view. Your objection, that question number 7, is that the the conditions of, or the protection of 25-26, the three constitutional exceptions therein, these are all personal issues. That somebody who has any grievance will come to the court and others have, you, a stranger
That-
can be permitted.
I'm grateful. That is the view, the minority view of Justice Indu Malhotra in Sabarimala takes. That a stranger who has nothing to do cannot just jump into the bandwagon and say that prevent it. Suppose, my lord, some
Tentative observation by my sister is also.
Petitioners be aggrieved. They are strangers.
cannot, my lord, there are some young lawyers.
What is
It's
the
a-
causal connection?
It's a PIL, it's a Young Lawyers Association.
Mr. Solicitor, we all know we have all practiced in the trial court. If a suit had been filed by such an association, the first question would have been on Order 7, Rule 11A. No cause of action, no causal connection.
Yes.
Complaint would have been dismissed.
My lord, for now, my last, my lord, my satisfaction, come to page 120. My lord, please come to 120 and my lord, I end. 120. This is apropos your ladyship's question. And I'm not, my lord, reading. Just see the question frame. And in my submission, I have given all judgments on the point. This has to stop, my lord.
Where it has.
This has to stop. Please see 120. 120, my lord. Question number 7. Your lordships may see, your ladyship may see question number 7. Whether a person, your ladyship has got 120. 120. It is whether a person not belonging to a religious denomination or religious group can question a practice of that religious denomination or religious group by filing a PIL. This is the question frame. My lord,
Expected that this would be addressed first, Mr. Solicitor.
it was framed as question 7, my lord. Sequence was not ours. But, my lord, 120 onwards, full submission, it could have been dismissed only by two-page judgment that you have no locus, you are not concerned, you are only an interpolar, and you're none of, it's not your right which is concerned. For 25 and 26, you must be a person within that denomination.
Person aggrieved.
Person aggrieved.
Causal connection, AR 1976, Supreme Court, JM Desai, the judgment of this court,
Wait, my lord.
Your ear is probably
578.
correct. If it was to be dismissed at the threshold, it should have been done in 2006.
Now we'll have
Since of which year?
2006.
And not to forget,
It's filed in 2006, that's what I was pointing out. So we are today 20 years down the line. Now, if you want to dismiss, we are ready to pack up and go home. And the reference must be discharged.
That's why I said that it should have been done in 2006 if it was.
My lord, either we address you or we don't on the merits. If your lordship feels that there is no need for an address on merit, kindly discharge the reference. And we will deal with the situation as and when it arises on the facts of each individual case. There
No,
are
but-
7 cases pending here, a
But
Parsi woman,
The,
a Muslim woman.
exactly, those issues are also there.
Yes, my lord, they're all there.
Those issues will also be there.
Facts, my lord, on different
addition to-
religions.
Well, suppose I file a petition that permit Muslim women in the mosque. Well, how am I concerned? Would the court not ask me? That's the question number 7. Then let an affected lady come. So, but
That is why he
That
asked
comes
that
to address
no
on the merits of this
devotee
reference.
challenged it. No devotee would have
as needs.
challenged it.
Yes, yes.
It is a person who has no concern with it, who has come to the court.
120 onwards are all the judgments that this petition is not maintainable.
Petition, that was the
You know,
petition, this is
what this question number 7 raises is two issues. The direct interest of a person, that can file a PIL. But a large number of PILs are filed, my lord, because the carriage of proceedings is by somebody else. Suppose there's somebody from the backward class. Somebody from the forward class says, I carry the proceedings. Now suppose somebody comes along and says, I'm the carriage of proceedings on behalf of Hindu women. Would your lordship dispose that off at the threshold?
Yes, because no devotee of the Lord is challenging it. And why should this court concern about a non-devotee?
May I make myself clear?
No non-devotee. This court cannot concern with a non.
No, let us complete.
Let the solicitor complete.
There is a lawyers association that comes along.
Correct.
And says a lot of Hindu women are in fact being denied
That's
access
it.
to the temple. Do they have the carriage of proceedings?
They do not have, that's my answer.
Not devotees, because a devotee.
Lord, is he supporting the review petition?
The point is today, in fact, today we have crossed that bridge. The questions which have been formulated and 5, 6 of questions which have already been addressed partly.
Yes.
And the answers and responses will come. These questions are likely to have, and in fact will have, a direct impact on the reference, on the review. Therefore, it is.
But on 6 other petitions which are pending.
Alright, see.
But therefore, it is in all fairness that we hear all of you and form an opinion.
Tell you,
Saying is, this will impact on the concept of PIL.
here.
no, it's okay.
We wish to argue that only.
This issue
We
has-
wish that PIL,
Issue has to be answered.
give me 5
Let
minutes.
let us assume it goes against you. As we are trying to argue before, the next issue will be what extent in the sense let us assume, can the court presume that these persons, they represent the larger part of the society or the collective belief of
No,
the
religious
entirety?
freedom.
Now, we'll tell you why. For Supreme, I will take it. In example, we are going to the marriage. Let us, there are 100 women are there. 99 of them, they believe that the sanctity of the practice will not be upheld.
Nobody goes in.
Therefore, we don't want to go. If somebody goes, it will go against our own belief. It is possible. We just hypothetically will say, can the court ignore that and then decide it, which will have a bearing on their own faith?
If they come, yes, they
Then-
can.
No, then
I'm
do we have a parameter? Do we have a parameter to say that it will be binding on them also? Because whatever we decide will have a substantial.
Your
impact
lordship,
on
sir,
the
I correct.
That is why you have to read it subject to the rights of the larger. You also refer to this.
Yes, comparative.
Right, this is a larger right.
I have been
So-
using an expression and in 2 judgments also I used, but I first time used in the High Court, invisible victims of a judicial system.
Yes.
I use the word invisible victims of a judicial
Lord,
system.
it may be a vice.
Lord, I have used it, my lord, a different way. It is a fight between silent majority versus very vocal minority.
We have a right to be
And
vocal.
it's not, my lord, religious minority, viewpoint minority. My lord, last point. Let me complete my last point.
Vibrant, I think all right.
Can I make a suggestion? Would it be advisable if it pleases you?
That's
My
why,
lord,
Sir, let
Lord,
me complete
I'm
my
only
last.
suggesting, my lord, is it necessary
Let
to
me
decide?
complete my last point, ma'am.
Lord, is it necessary to decide 7? Can we have it deleted, my lord? Since we've already addressed you on everything.
No.
We have already addressed you.
My lord, last point, and I'm not, my lord, I'm closing my file. Last point on this question of PIL jurisdiction, please examine your lordships. Rarely sit in this combination of 9. Lord, PIL jurisdiction was initiated in Bandhua Mukti Morcha, where people had no means to approach the court. I have given, my lord, in my written submissions. Now the judicial system has become so transparent and virtually catering to the doors of the litigant that by e-filing, one letter can reach the court. Now nobody needs to represent any unrepresented class. NALSA is there, my lord, District Legal Services Authority is there. If someone has nothing, my lord, then he can go to District Services Authority, that this is my fundamental right, it is violated, advise me. Or give a petition to the Supreme Court or the High Court on my behalf. Now, why, my lord, entertain all these PILs? And PILs generally we know are motivated PILs. My lord.
Mr.
Somebody else is behind the back.
Mr. Solicitor, the answer is very simple. Nowadays, and nowadays does not mean that I'm talking about last so many years now.
Yes.
The court themselves are very, very circumspect. They are very, very extraordinarily cautious of entertaining PILs. We have laid down the parameters of testing the bona fide, the locus, the real cause, the so many factors we are nowadays testing. And given a day when you sit in court number 1, you must have seen that how many PIL we entertain. We
No,
totally
your lordships are very circumspect.
maybe that in 2006 to now 2026, in 22 decades, the situation has gone a little more or more cautious. The point is today in this issue, on general principles, PIL, we need not even hear you, we are agreeing to that. That the court will be very, very cautious in entertaining a PIL in these days, particularly when people come with different kind of agendas. And
They are
this court started way back.
business rivalry in disguise. Business rivalry in disguise. Somebody is always there to back the PIL petitioners.
So, we are conscious of those principles. General principles we are aware, but the point is that here APIL was entertained in 2006.
But, my
It
lord,
has been
in,
decided
your
on
lordships may have to decide on a point, short, limited point, whether in case of freedom, religious freedoms, a stranger can come. That's all.
This can be one of the parameter for the purpose of maintainability of a PIL. That should be maintained PIL in this kind of.
Yes.
That can be one argument. We can examine
Yes,
that
yes.
part in a given case. But general principles are well known.
Lord, I'm grateful, my lord.
Thank you. Now, Mr. Vaidyanathan.
Yes.
Mr. Dhawan. And Mr. Dr. Singhvi. During lunchtime, I got a message from one of my friends from media. My friend means the person in media knows to me that if you have observed principle of seniority, then Mr. Vaidyanathan is probably the senior most among the senior lawyers who are appearing, and then Dr. Singhvi probably, and then Mr. Dhawan. So, how much time, Mr. Vaidyanathan, you will take?
About 90 minutes, around 90 to 100 minutes. Less than, no, 1.5 hours.
Well, there was another
How much
aspect.
will it take?
I've asked for more, but I will take 2 hours or so.
And immediate after that, Mr. Dhawan, we will hear you.